I'm just gonna ask for.
Good afternoon. This is Dale Rodriguez, certified Spanish interpreter. This one.
Can the interpreter hear me?
Yes, this is interpreter. I can hear you. Can you hear me?
Excellent. Yes, thank you. This is Judge Carter. I'm at the BRC. I've got the defendant at the podium. Is the headset connected?
Ahora sí mejor.
This is interpreter. Connections been established.
Excellent, thank you. This is case number 23 CT 2419. Sir, please tell me your name.
Harry Antonio Paz Fuentes.
Jare Antonio Paz Fuentes.
Sir, you were arrested for driving without a valid driver's license. There is probable cause.
received.
Okay.
Based on the arrest affidavit, driver's record, it merely states mental report. Never possessed a Florida's driver's license. Without more information, there's no PC to prove not possessing.
Just for a no valid driver's license, they have to not have a valid DL. The officer's statement that he DL would be sufficient for PC. But for running it.
I think there's also probable cause. It says citation issued, there's a citation attached. So I think that there's probable cause for the offense. Sir, did you want to resolve your case today? Did you want to enter a plea?
Sí, 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 por responsabilidad.
Yes, I'll plea.
State there can be an offer of a withholding credit. Offer, I believe, for potential.
Not able to speak with him because of.
This interpreter. I apologize. I'm having some difficulty here in the state.
I was not able to speak with Mr. Fuentes because of the language barrier.
At this time, I'm going to release Mr. Paz Fuentes on his own recognizance. Sir, you are going to be given a court date when you leave the jail. I'm also going to appoint the public defender to represent you. You need to make an appointment with the public defender before your next court date to determine how you want to resolve your case. Thank you, sir. Ma'am, good afternoon. Tell me your name, please.
Lizaida Lleras Colón.
Lizaida Lleras Colon.
This is 23 CT 527. Your arraignment for the offense of driving a car without a valid driver's license.
There can be an offer to Ms. Cologne of a withhold of adjudication and credit.
Ms. Cologne would like to accept the state's offer and enter a plea of no contest, Your Honor.
Thank you. Ms. Cologne, it's my understanding that you wish to enter a plea of no contest to the offense of driving without a valid driver's license. Is that correct?
Correcto.
Correct.
Did you have an opportunity to review this plea form I'm holding before you signed it?
Sí.
Yes.
Do you have any questions about any of the constitutional rights that you're giving up?
Estoy de acuerdo con todo.
I'm okay with everything.
All right, do you have any questions about this form? Anything that you read on the form?
No. Estoy-
No.
Are you currently under the influence of any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No.
No.
Are you on probation?
No le escuché bien.
This interpreter, it seems that the defendant's having some trouble hearing me.
Ma'am, are you currently on probation?
Sí.
Where are you on probation?
Sí.
I'm just gonna have you take off the headset.
She's saying she can't.
That's fine, just
Want to
take the
try
head.
it over?
Yep. Mr. Interpreter, if you could just interpret over the loudspeaker for me.
Yes, Your Honor.
Ma'am, if you'll just interpret this, the headset's not working, so we're just gonna do it over the loudspeaker.
Señora, los audífonos no están funcionando, así que vamos a estar haciendo esto por el altavoz.
Ok.
Okay.
So I'll ask you the question again. Are you currently on probation?
Le volveré a preguntar, ¿se encuentra cumpliendo un régimen de libertad vigilada por algún otro ilícito?
No.
No.
And do you understand if you're not a U.S. citizen that this plea will result in your deportation?
Y además entiende que en el caso de no ser una ciudadana estadounidense, al aceptar la responsabilidad por el ilícito quedará sujeta a un proceso de deportación. ¿Entiende eso?
Sí.
Yes.
All right, ma'am, at this time, I will accept your plea, withhold adjudication, sentence you to 8 days in jail with credit for 8 days' time served. You will have to pay court costs. Those will be due 1 year from today, or you need to see the clerk for a payment plan. Thank you, ma'am. Those are all the interpreter cases we have this afternoon.
Muy bien, señora, entonces se va a aceptar su declaración, se dicta fallo de culpabilidad. En suspensión se le va a sentenciar por 8 días en la cárcel y se le va a acreditar por los 8 días ya cumplidos. Tiene que pagar las cosas judiciales y se le va a conceder el plazo de 1 año a partir de la fecha de hoy. Y si también puede hablar con la secretaría para que pueda cuadrar un plan de pago. Gracias.
Thank you, Mr. Interpreter. Sorry about that.
You're very welcome, Your Honor. Have a great day.
You too. Yes. All right, well, we will reset Mr. Lafferty for, once he's released from mental health status. So 24 hours from his release. from mental health status.
Your Honor, I'll waive the appearance. We don't believe he's going to be able to appear tomorrow either due to mental health. I think he needs to get regulated.
Okay, so that's 23 MM 2388. He was arrested for trespass on property after warning. There's probable cause. He's not to return to the Wawa. I'll stay the bond at $500, and I'm
Thank
not
you.
going to take any action on the out on bond case. Sure. Mr. Torres? Sir, good afternoon.
Good afternoon.
Tell me your name, please.
Nathaniel Xavier Torres.
Mr. Torres, this is 23 CF 4528. You were arrested for possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, armed burglary of a conveyance with a firearm, and burglary of a conveyance.
Is this the one? Oh, sorry, I have the wrong Taurus. Is this the one we were talking about? Your Honor, I would argue no PC as to the possession of a, trying to find it, firearm by a convicted felon. I would argue no PC. There's no indication based on the affidavit that he was in fact a convicted felon other than the statement made by the police officer. He does not reference a case in the affidavit. Let's see. Hold on, I gotta look. Just a second.
It says Torres was identified and OPD teletype confirmed Torres as a convicted felon in the affidavit. So I find that there is probable cause based on the affidavit. At this time, the court is going to set bond on count 1 at $2,500. Bond on count 2 is $150. Is count 3 a PBL?
Yes, Judge, count 3 is an F1 PBL. And given that he is a convicted felon, state would request that you stay at no bond pending an Arthur hearing.
Again, I already made.
Okay.
It's not.
I mean, at this time, I am going to say the bond on count 3 at none, pending an Arthur hearing. Once the defense files a motion. Count 4 burglary of a conveyance bond will be set at $100. And then the judge who entertains that can set the conditions.
No. I'm sorry, Your Honor. Yeah. Count 1, I'm sorry. You did count 1 and 2 at how much, Your Honor?
2,500, and then subsidiary, count 3 is none, and count 4 is 100.
Thank you. You have to have an Arthur hearing. Life. Jesus.
Counsel, I'm going to finish the move-up docket, and then I'll take your case, okay? Sure. Are you Marissa Williams?
Daviana Marissa Williams, yes, ma'am.
All right, thank you. This is 23MO337. This is your arraignment for the offense of camping. What?
She's gonna resolve.
Okay.
And state did convey an offer on behalf of the city of an adjudication, credit, court costs, and a $10 filing fee.
All right.
And she would like to accept and enter plea of no contest, Your Honor.
All right, Ms. Williams. Did you have an opportunity to read the plea form before you signed it?
Yes, ma'am.
Do you have any questions about any of the constitutional rights on the form?
No, ma'am.
Are you under the influence of any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, ma'am.
Are you on probation?
No, ma'am.
And do you understand if you are not a U.S. citizen that this plea will result in your deportation?
Yes, ma'am.
All right, at this time, I will accept your plea, adjudicate you guilty, sentence you to 32 days in jail with credit for 32 days time served. You will have to pay court costs, including the $10 filing fee. Those will be due 1 year from today, or you'll need to see the clerk for a payment plan.
Your Honor, she's not being released. Could you do could you do a year from date of release, because she has another
Sure.
case?
No problem.
And then I'll call her.
Thank you. Yes.
Oh, these are just arraignments, okay. Counsel, could you tell me your name, please? Sure. Ms. Cooper, and what case are you here on?
Yes, ma'am.
Mr. Troger. Could we bring Mr. Troger in? Thank you. All right, go ahead, Ms. Cooper.
Hi, Judge. Mary Jane Cooper, here on behalf of Mr. Troger in 2023 CF 4568AO. Judge, I do have a probable cause argument for 3 of the counts.
Okay, sure, go ahead. Well, first let me tell Mr. Troger, you were arrested for robbery with a deadly weapon, aggravated battery with a deadly weapon, criminal mischief over $1,000, grand theft 3rd degree, which is of the fire extinguisher, false alarm of fire, disturbing the peace at a public lodging, and loitering or prowling. Ms. Cooper, if you would like to make your argument, you may proceed.
Thank you. Judge, I do have an argument. The first one I want to make is for robbery armed with a deadly weapon. In order for there to be probable cause for a robbery at all, there must be a taking. The facts in the affidavit indicate that there was not a taking of property. And so based on just that alone, there is no probable cause for robbery.
Okay, I'll let Ms. Fleming, you respond to that argument.
One second, Your Honor.
So when I read it, it's in paragraph 2, he allegedly checks the pockets for the keys, but they're not there, and then I didn't see any other area where it would have been talking about the robbery, a robbery.
Yes, Your Honor, state would just ask that you find an attempt.
Did you want to be heard?
Judge, I would like to be heard. So we all know that hearsay is permissible for PC. However, the only indication that we have of give me your keys is hearsay within this hearsay document from an alleged victim who has not shown up today to provide sworn testimony. I have spoken with my client. He advised that he was looking for his own keys. And I think this is maybe a typo. And so I would argue against that as well.
Okay. I do find that there is probable cause for an attempted robbery with a deadly weapon based upon the facts contained in the affidavit.
Judge, I'm sorry. I had the PC argument for the robbery alone, but I also had PC argument for deadly weapon, for robbery with a deadly weapon as well.
Meaning the fire extinguisher?
Correct.
Okay, so go ahead.
So my argument would be a deadly weapon is any instrument when it is used in its ordinary manner contemplated by the design and construction to cause great bodily harm. Obviously, fire extinguisher is not that. There is also case law that says that objects not designed to inflict bodily harm can qualify as deadly weapons if the defendant used or threatened to use the object in a way likely to cause death or great bodily harm. And in that particular case, he did, as the facts are alleged in this affidavit, he did not utilize the fire extinguisher in a way to cause deadly harm. A hit to a forearm is far from deadly harm. And so I would argue that this was not a deadly weapon because it was not used in a way to intend great bodily harm or death.
Okay. Ms.
In
Fleming?
regards to the second way that it can be used or threatened to use in an object in a way that would cause death or great bodily harm, it is alleged within the affidavit from the victim's testimony to the officer that he sprayed the fire extinguisher in his face, incapacitating him with the smoke, reached down, checked his pockets, and then raised the fire extinguisher and tried to hit him in the head, to which the victim was able to block it. So the defendant's actions were used or threatened to use in a way that caused death or great bodily harm. He used or threatened to use it by hitting him in the head, which they would argue would cause death or great bodily harm if he did actually make contact, but for the victim raising his arm and blocking it.
Okay. So again, I think that whether or not it's a deadly weapon is a fact question that would be determined by a jury. So I think for the standard of probable cause, I believe that standard has been met, and I do find that there is probable cause for attempted armed robbery with a deadly weapon. Did you have any other probable cause challenges?
Not on this count.
Okay. Go ahead.
I would just preserve the argument for, the same argument for deadly weapon for count 2. For count 3, I would argue that spraying of fire extinguisher was not criminal mischief, did not damage or destroy property. It can easily be swept, wiped, and dirtying something is absolutely not criminal mischief within the statute or the meaning of the law.
All right, Ms. Fleming?
Your Honor, for criminal mischief, it has to be injuring or damaging the property, and it belonged to another person maliciously and willfully. It is alleged that it was in multiple places. I believe the multiple floors, the stairwells. It sprayed down so heavily, a thick layer of powder covering everything. Everyone had to be evacuated, and they did estimate damages to be about $7,000. So state would argue that that's enough for PC for criminal mischief at this time.
Right, again, I do think that the standard for probable cause has been met, whether a reasonable person would believe that the crime had been committed. So again, I do find probable cause for criminal mischief. And then I do find probable cause with respect to count 2 as well.
And the last one is loitering or prowling. Judge, it is also alleged in the affidavit that he was a patron at this hotel. He was staying in the hotel. So there would be reason for him to be in the property. He also had a vehicle that was parked in the hotel parking lot. And so I would argue that there's no PC for the loitering or prowling.
Ms. Fleming?
State has no argument, Your Honor.
I would agree. So he'll be ROR'd as to count 7. Ms. Cooper, did you want to be heard on bond amount?
Judge, I would just ask that he be given a bond that's within his financial reach. For count 1, obviously, he was arrested with no bond, but with attempt, he is entitled to a bond. I would ask for,
Did you want to swear him in and take some testimony to establish what he would be able to afford and what his ties to the community are?
I can.
Okay. Sir, could I have you raise your right hand, please?
Yes, ma'am.
Thank you. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, it is, ma'am.
All right.
Mr. Troger, do you have an address that you can stay at during this pending lawsuit?
Yes, ma'am. It's 4409 North Hoffner Avenue, and that's Orlando, Florida, 32812.
And how long have you been living in Florida?
I've been in Florida, let's see, for 2 years now.
2 years. And do you promise to appear for any court appearance that you have?
Absolutely, ma'am.
Have you ever failed to appear for court in the past?
No, ma'am.
And what was your previous occupation?
Previous to now,
Yes,
I was a police officer.
thank you. And in addition to that, will you remain in contact with your attorney, me?
Yes, ma'am.
Okay, perfect, thank you.
What about his ability to pay?
How much can you afford for a bond right now, at this moment?
Ma'am, I'm an airline pilot. I'm out on medical. I had complications of COVID in flight in December. I'm not obviously going on big lavish vacations or anything right now. So I guess the number would be, 14,000, I don't know, $10,000 or 14 or whatever.
Is 10,000 more affordable for you than 14,000?
Yes, ma'am. it is.
Okay. So Judge, I would ask if we could make the bond 10,000 total for the 5 counts.
Your Honor, I do have one question.
Sure.
How long have you lived in Florida?
Asked and answered.
2 years.
You can answer the question, Mr. Troy.
2 years on and off, but the problem is they have us based all over the place, so I'm constantly
So you're constantly traveling?
traveling. But I'm no longer, ma'am, for the record, I'm not flying right now because my medicals, because all the complications I had with COVID, so I'm only staying in Florida.
Understood, thank you.
Mr. Troger, which airline do you work for?
JetBlue Airways, ma'am.
Okay. When did you go on medical leave?
I've been out since December.
Of 2022?
I'm sorry, yeah, January technically of 2023.
January 23?
Yeah,
When do you plan to return?
I probably won't, ma'am. I had a seizure in flight, complications from COVID.
Okay.
Something had happened with brain swelling. They think, they don't know, it's so new.
Okay. Where's your family?
They're in Scottsdale. I was just visiting them this last weekend.
In Scottsdale, Arizona?
Yes, ma'am.
Okay. Do you have any family here in Orlando?
No, but all my very close friends are all here in Orlando because our training center's here, and my really close support group that have been really close to me.
Okay. Whose house is the house on Hoffner?
My best friend, Nick Brown.
Okay. Could I have the attorney's approach? Thanks. sure, I just didn't feel like I. All right. All right, so Mr. Trover, I am in a, order that you are not to return to the Aloft Hotel,
ma'am.
okay? You are not to possess any weapons or firearms. And you are not to leave the state of Florida without permission from the court,
Okay.
okay? And I understand that you do have family in Scottsdale, and that's where they are. And I'm sure that Ms. Cooper, if it ends up that you need to go be with family, she can file a motion with the court and get that resolved for you. I'm also gonna have you follow up with your medical provider
Yes, ma'am.
when you're released from the jail, okay? And I'm sure, again, Ms. Cooper can help facilitate that and make sure that you follow up with your doctor. I am going to set bond on count one at $5,000. Bond on count 2, 3, 4, and 5 will be $150. And bond on count 6 is going to be $100. Mr. Troger, do you have any questions about any of the conditions of your release, sir?
No, ma'am.
Okay, thank you. Thank you, Ms.
Thank you, Judge. I have nothing further. May it please be excused? Sure.
And Madam Clerk, the statute, it'll be 812.13, sub 2, sub A, and the attempt needs to be added in at 777.04.
I'm sorry. The attempt statute.
812.13.2A and 777.04.
Thank you, Ms. Fleming. All right, is this Mr. Estrada? Yes, ma'am. Good afternoon, sir. This is 23 CT 1720. This is your arraignment for driving while license suspended. It does not look like you are currently represented by counsel. Sir, did you want to see if you qualify for the public defender? Or,
Yes.
yes, okay. Are you currently, well, I know you're in custody right now, Mr. Estrada, but are you working out when you're outside of the jail?
Yes,
What kind of work do you do?
I work for 2 places. I just started at Rigo's, and I just had a little part-time for working at a kitchen.
All right, how much money do you make per week?
Like I get every 2 weeks like 4 something.
All right, do you have any dependents?
Yeah, I got 7 kids.
All right, so I'll appoint the public defender to represent you, sir.
We're gonna enter
When he was brought over for the
driving while licensed.
driving while license has been revoked, that bond's been paid since 4/5.
Yeah, but I think he's being held,
He is on a VOP. He's
Yeah.
being held on that.
but his arraignment will be here since he's here, no? Even if he paid the bond?
Okay.
I think that's what happens.
Okay. Making sure it's not gonna cause any conflict with what you're
Oh,
doing.
no, I don't think so.
Okay.
So you're gonna enter a plea of not guilty?
Yes, Your Honor.
Okay. This is a Division 81 case.
Pre-trial conference date will be May 5th at 9 a.m. in courtroom 6B.
Thank you, Mr. Estrada.
All right, thank you.
Tell them to take it out.
Huh?
Tell them to take that out.
What the vehicle? Oh, yeah.
Sure.
It,
If you'll just restate the.
It's showing on yours?
It's 23 CF 4568?
4568, 23 CF 4568.
Yes.
He's right here.
Okay.
Can I just ask for a one-time return with law enforcement to a loft to get his belongings that are inside the hotel room?
Yes, just make sure you tell him to call the non-emergency number and for law enforcement, for OPD, and then they will meet him over there and help him with that.
Okay, thank you, Judge.
You're welcome.
They said have no contact with the victim, correct?
Yes.
and Your Honor, on Estrada, I don't know why it's showing that he's being held on this. He shouldn't be. Apparently he posted the bond on this case already, so I'm not sure why it's holding him. I'm
I
not.
thought he was only held on the VOP.
Me too. I just wanted to make sure.
I don't know what showing he's held.
Yeah, that's all it's showing. That's what I was saying with the bond. I didn't know why we'd
Well, because if it was set for arraignment downtown and it showed he was in jail, even if he's not in jail on this, they
Right.
would set him for in-jail arraignment.
I should tell the people downstairs to remove that when I get down there to remove the bond.
No.
He already paid the bond on that case.
Oh, that's.
Right.
Okay.
I mean, he would
So
have
it's
to
fine.
go, right,
Okay.
so if he doesn't want, it's up to him, right? I mean, if he ends up resolving the VOP, I don't know what he's gonna do with it. But if he didn't wanna have a bond on there, right, then he would have to have whoever's helping him with the bond, talk to the bondsman to come off the bond.
Okay,
Right?
okay,
You
that
see
makes
what I'm
sense.
saying? Like, I have no reason to revoke it, I can't do anything with it.
Okay.
Okay, how about Mr. Rodriguez? All right, Mr. Rodriguez, this is 23 CT 1737. This is your arraignment. Looks like this was a violation of probation on a driving while license suspended case.
Mm-hmm.
And he's not represented by the public defender?
No.
Okay. Is there an offer for Mr. Rodriguez?
Not at this time, Your Honor.
Is Mr. Rodriguez here on anything else?
Yes. Yeah, yes. This is Michael Rodriguez.
Mm-hmm.
And he's in here today on the driving charge, CT. driving charge. Looks like he has violation of probation, grand theft, motor vehicle, sale and delivery, possession of cocaine. I don't see the drive.
Grand theft motor vehicle, sale and delivery within 1,000 feet of a childcare facility.
That's 5 different charges.
Can't resolve it because you're here for a VOP on this case. Can't resolve that case today. There's no offer.
2 no bonds and $10,000 bond.
Mr. Rodriguez, I'm gonna appoint the public defender to represent you, and your, looks like your, VOP day in division, Judge Allen, Division 8, May 18 at 9 a.m. All right, thank you, sir. Mr. Hidalgo? All right, how about, Benavente Hilgaldo? Oh, okay, no problem. Sure. Mr. Gonzalez, this is 23 MM 158. This is your arraignment for the offense of
But he never came.
And state did convey an offer to Mr. Gonzalez of an adjudication credit, no return to O'Reilly's Auto Parts at 13100 West Colonial, and restitution in the amount of $203.49 to O'Reilly's.
Yep, and it's gonna make it worse.
So there is a charging document, so we can accept a plea if he wants to.
If you plead it, you have the bond amount on this case? He's not being held on this, right? Because it's
No.
a notice to appear.
Correct.
I'm not. I know, that's why I told you. We're gonna enter a plea of not, yeah, we're gonna enter a plea of not guilty, Your Honor.
Okay, no problem. So, sir, this is a Division 84 case. Your pretrial conference date is,
May 11th at 8:45.
all right, thank you.
I'm sorry, what was the court date?
May 11th at 8:45 in courtroom 4B.
I'm done. It's like a full moon, I'm sorry.
Oh, and this morning was a nightmare for me in my courtroom. My Cisco didn't work. It was a full packed house, had to go off the record so they could fix it. It was fun. It was good Monday morning. So no worries, we'll get through. Is this Mr. Hidalgo?
Yes.
All right, sir, this is 23 MM 59. This is your arraignment for the offense of trespass in an occupied structure or conveyance. You are represented by the Office of the Public Defender. How would he like to proceed?
The offer from the state was an adjudication of guilt, credit time served, no return to 901 North Orlando Avenue, I believe. And there's a cost of investigation in the amount of $406.06 to Winter Park Police Department. And he would like to accept the state's offer and enter a plea of no contest.
Yes.
Mr. Hidalgo, did you have an opportunity to review that plea form and your case with your lawyer before today?
Yeah.
Yes, sir? Okay. And you'd wish to accept the state's offer?
Yeah.
Do you have any questions on any of the constitutional rights on the plea form?
I'm all right.
Pardon me?
I'm okay.
You understand?
Yeah.
You don't have any questions?
No.
Are you under the influence of any drugs, alcohol, or medication that would affect your ability to understand what's happening in court?
No.
Are you on probation?
No.
Do you understand if you're not a U.S. citizen that this plea will result in your deportation?
Yeah, I'm citizen.
Okay,
Oh, yes, sir.
okay. So, sir, at this time, I'm going to accept your plea. Was it a withhold or an adjudication?
It was an adjudication, Your Honor. There's other history.
And I will adjudicate you guilty,
I'm sorry.
sentence you to 17 days in jail with credit for 17 days time served. You are not to return to the scene. You have to pay court costs, including a cost investigation to the Winter Park Police Department, in the amount of $406.06. Those will be due 1 year from today, or you will need to see the clerk of the court for a payment plan.
And Your Honor, just so there's not confusion, this case came in also with a possession case, possession of amphetamine. We haven't filed on that one yet. I just want to make sure that he's not confused so he doesn't ever not come back up. Do you understand what I'm saying?
So, Ms. George, did you hear that?
I'm sorry?
So apparently this came in with a possession of.
Yes, that's what I
amphetamine?
was just explaining.
Okay, so we're good?
Mm-hmm.
Okay, thank you.
$500 bond.
Yep, I have it.
Ms. Carroll? Good afternoon, Ms. Carroll. This is 23MM2393. You were arrested for trespassing.
And, Your Honor, I don't have a PC challenge, I'm sorry.
That's okay. I'll find probable cause. I'll appoint the public defender.
I would ask for an ROR. She has no history, and she does have a phone to keep in contact with the attorney. I just want to try to keep it off of her record.
Okay, no problem. So, Ms. Carroll, at this time, I'm gonna release you on your own recognizance. You are gonna be given a court date when you leave here. You must show up at that next court date, or a warrant will be issued for your arrest. You also need to keep in contact with your attorney. Ms. Carroll, do you have any questions about that? All right, thank you. Mr. Franklin? Good afternoon, sir. This is 23MM2392. You were arrested for trespassing, and there's probable cause. Was there an offer for Mr. Franklin?
Yes, Your Honor, however, he has an eval pending in a different case, so I just ask that you stay the bond.
All right, Mr. Franklin, at this time, I'm gonna stay the bond in order that you're not to return to the Liberty gas station. Thank you.
We can't put eval pending in your other case. Your serious case.
Mr. Haskins? Hello, Mr. Haskins.
How you doing?
Sir, this is 23MM81. You were arrested for trespassing. There is probable cause. I'll appoint the public defender. Was there an offer for Mr. Haskins?
Yes, state to convey an offer of a withhold credit and no return to UCF properties.
Your Honor, again, he has no criminal history. We would ask for an ROR as well as trying to help him with services in this case.
All right. Mr. Haskins, I'm going to release you on your own recognizance at this time. You're going to be given a court date when you're released from the jail. Do you know where the Orange County Courthouse is?
No, but I can research it.
Okay, it's right down on Orange Avenue, right downtown. You've got the contact information there from your lawyer, so they can assist you with that as well, but you do need to be at that court date or a warrant will be issued for your arrest. Do you understand?
When is the court date?
They'll tell you when you're released,
Yes, ma'am.
all right? And you can't go back to the UCF campus.
Can't go back to the campus?
No, sir.
I gotta call them to go get my book bag from up there.
Okay, I'll allow you to go a one-time return. with law enforcement to get your things from the campus, okay? You'll have to call the non-emergency number, and they'll explain to you what you need to do.
Yes, ma'am.
All right, thank you, sir.
While we're waiting on the next one, can you give me your next one and I'll tell you, because we got quite a few bonds.
I have Christian Rembert,
Remember bonded,
okay? Christopher Rivera,
Rivera bonded,
and then we've got Octavius Dubose,
DeBose bonded,
Celestine, Cuba,
Cuba was released, PTR,
and then Treese Jackson. All right. Good afternoon, Ms. Jackson. Ms. Jackson, this is 23 CO 413, ma'am. You were arrested for loitering for an unlawful purpose. I am going to appoint the public defender to represent you.
There's no offer for the new charge, Your Honor. There's just an offer to resolve her out on bond.
Okay, what's the offer?
An adjudication, credit time served, and Ms. Jackson would like to accept the state's offer and enter a plea of no contest.
All right, Ms. Jackson, did you have an opportunity to review the plea form before you signed it?
yes, ma'am.
Do you have any questions about any of the constitutional rights on the form?
I'm just thankful.
Okay. Are you under the influence of any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, ma'am.
And are you on probation?
No, ma'am.
Do you understand if you're not a U.S. citizen that this plea will result in your deportation?
Mhm.
Is that yes?
Wait, you said I'm not a U.S. citizen?
If you are
Oh,
not.
got you. Yes, ma'am, I understand.
Okay. At this time, I will accept your plea, adjudicate you guilty, sentence you to
26 days.
26 days in the Orange County Jail with credit for 26 days time served. You will have to pay court costs. Those will be due 1 year from today, or you need to see the clerk for a payment plan. On the new case, Ms. Jackson, I am going to release you on your own recognizance today. You cannot return to that area.
I won't.
Do you understand?
Yes, ma'am.
Okay, do not return to the area. And then you'll get a court date when you're released here from the jail today. You have to appear at that court date or there'll be a warrant issued for your
I
arrest.
have one question.
Sure,
So the first, I had,
it's gonna be canceled,
got you.
Yeah. that's all that can-
Whew, you a blessing.
but you're gonna get a new one.
Yes, ma'am.
And you have to be present at that one and you can't go back to the area that's
At
the
all.
South Orange Blossom Trail in Sand Lake to Taft. You got it?
Yes, ma'am.
Okay, all right, thank you.
God bless you. Jordan, Octavia?
Yes,
Bonded.
okay.
And I did have PC on this.
Mr. Lewis?
Yes, Your Honor. Hi,
Good afternoon, Mr. Lewis.
Hello.
In this particular case, Your Honor, I would argue no PC, as based on in the affidavit, it does not state the alcoholic beverage was open. It just states that it was on the ground and placed into a bag. So I'd argue no PC as to the open container portion.
Your Honor, I believe it states within the affidavit, due to the fact Lewis was witnessed by officer didn't hold an open alcoholic container in Lake Eola.
No, I didn't see that part. You said it says open?
Yeah, it does.
Oh, okay, I just saw it. I didn't see it either. Oh, I missed that part. I
Okay.
didn't see the last part where it says open. I read.
No problem.
It is
So,
open.
Mr. Lewis, I do find probable cause in 23 MO 486 for the open container. Did you want to resolve that case today, sir?
That's not the, but I did go over the offer with him, Your Honor. The offer was an adjudication credit time served, no return to 312 East Central Boulevard. If you want to resolve.
Mr. Lewis, what'd you want to tell me? I felt like you wanted to say something.
Yeah, that bottle, the guy was showing me the bottle, and they could have gave me alcohol since I haven't drunk nothing. He showed it to me, and I grabbed it, and I looked at it, and they came up behind me, and I handed it back to him.
I understand. So, Mr. Lewis, I don't have the authority to dismiss the case. That's not what I do. I understand what you're saying. I don't have any reason to not believe you for it. You can certainly have a trial, or you can resolve the case today. That's up to you.
I'm ready to go.
All right, okay.
don't go back to Lake York.
That's right.
Yes, Your Honor. I mean, yes, Your Honor, yes.
I cannot go back in Lake York Park.
Nope, you gotta find somewhere else to hang out, Mr.
Ain't no
Lewis.
problem, there's no problem, ma'am.
All right. So, Mr. Lewis, you read that plea form before you signed it?
No, I trust you.
Yes, you did. This is the form I told you to read. You got it in your hand.
I can't read it right now.
All right, so
I
Mr. Lewis,
went
just
over
look
it.
at me. Mr. Lewis, just look at me. Let's just slow down. Okay, so, but you understand by entering this plea today, it's okay that you didn't read it, but you understand that we're not gonna have a trial on your case and you're not gonna be able to present the defense that you just told me in court today. Do you understand that?
Yeah.
Okay.
Yeah.
All right. Are you currently under the influence of any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
I'm not on nothing.
All right. Are you on probation?
For what? No, ma'am.
I'm just asking. I have to, Mr. Lewis, I just
No,
have to
no,
ask.
ma'am. No,
I just-
ma'am, no.
Okay. And do you understand if you're not a US citizen that this plea will result in your deportation?
Yes, ma'am.
All right, sir. This time I'm going to accept your plea, adjudicate you guilty, order you not to return to Lake Eola, okay? And you'll have to pay court costs due 1 year from today or see the clerk for a payment plan. Thank you, Mr.
I knew
Lewis.
that.
I need this.
Get out.
How about Miss Mallard? Okay. That's okay. Mr. Pagani? Or,
This one, Your Honor, there is no PC.
This is the co-defendant, and this one, they don't write open within it.
okay.
However, he has basically no criminal history since 2001. So they would have no objection to an ROR, just out of fairness since the other guy,
Okay.
co-defendant.
So, Mr. Pagani, you won't be able to resolve this case today, but I'm gonna release you. You're gonna be given a court date when you are released from the jail. You're gonna have to appear at that court date, okay? So just make sure you're there, otherwise they'll issue a warrant for your arrest. It's gonna be at the courthouse downtown on Orange Avenue.
Okay,
All right, you can't go back to Lake Eola either,
okay, forever?
for now,
Okay,
okay? Until further, you're told something different by the judge, okay?
okay.
All right, thank you, sir. Yes, thank you. All right, this, Mr. Allen?
Yes.
All right, Mr. Allen, you are here, sir, in 23 CF 4035. You were arrested pursuant to a probable cause warrant for burglary of a structure and grand theft third degree. The offense dates were before the date for which he's here on, so I won't be revoking the bond or the PTR. Bond on count one is $2,500. Bond on count two will be $150. No return to the scene, no contact with the victims. You do have another driving case, sir, 23 CT 2421. You were arrested for driving while license suspended. There's probable cause. The bond's $500. Do not drive without a valid driver's license. You understand? We're on the same page?
Yes, ma'am. All of it's $500, you said?
No, you've got 2,500, 500, and 150.
Okay.
Okay?
All right.
Thank you.
Thank you, ma'am.
Not a bond case?
No action.
No action.
This Mr. Bryce Nolugo?
Yes.
Did I say that right?
Rolando Briceno Lugo.
Bryceno Lugo? Okay, sir. You've got 23 CF 4539. You were arrested for possession of cocaine within 1,000 feet of a convenience store. And there is probable cause for that offense. I'll appoint the public defender to represent you, sir. Your bond's $2,500. You were also arrested in 22 MM 1619 because you failed to appear for trial back on the 7th of March. Did you want to resolve that case today?
Yes.
Okay. Does he have any time in on that case? Do we know? Sir, do you understand that an offense for petty theft is an enhanceable offense? And if you were to be charged with petty theft again, it could be enhanced to a felony? you understand what I'm saying to you?
Yes. What is the charge for this? Well, what are we looking at today? The
Well, you failed
petty
to
theft,
appear,
a petty theft from Home Depot, right?
right.
Okay.
What I'm explaining to you is that petty theft, as the offense in general, is an enhanceable offense, meaning the more you get convicted of it, the worse it becomes. So right now, it's a misdemeanor, and then it can become a felony. You understand that?
She has to.
Like, he was in 11 days before, and then he's been in here for 2, so is it 2 days time served from what he's in on today?
I'm not,
He had 11 before.
I think they had,
That makes sense.
There was,
There was
that there
that-
was a global.
yeah,
And in the middle of the global, he backed out of it.
because of immigration issues.
Yeah, mid-play, he decided he didn't want to do the global. That was December of
I can just
22.
leave it alone.
Still trying to resolve. Because of immigration, did you speak to immigration?
No.
It says that he's a resident alien, but I don't have any kind of,
So,
he says.
he wants to resolve it. I just wanted to let him know that possibility, Your Honor.
All right, so if he wanted to plead to that today, I would adjudicate him guilty, and it would be 13 days with credit for 13 days, along with court costs. Do you want to accept that offer, sir?
So,
So I don't want to. I'm cool.
they cheated you a year.
On the street.
You just explained that he can't afford the court costs right now.
Oh, that's all right.
And the state would request no action on his out on bond. We haven't yet filed on it.
And then no return, let me see the location.
It would be no return to the Home Depot located at 7423 Southland Boulevard in Orlando.
Is there a cost investigation?
No.
Okay.
It's Orange County.
All right, sir, so you'd like to accept the offer to resolve your case to the petty theft that occurred at the Home Depot. The resolution would be an adjudication of guilt, credit for time served, and court costs. You'd like to accept that offer today?
No course.
I have to impose the court costs, but I'll give you a year to get them paid.
I don't know how much it's gonna be.
What?
I don't know how much would the court cost.
They're gonna be $301.
Okay, I guess.
Well, I have no wiggle room on that. I'm required by law to impose them. So no matter what, those are getting imposed unless you were to be found not guilty at trial.
The opponent's not even paying.
So, sir, again, I'm asking you, you want to accept that offer?
That's fine, yes.
Okay. And did you have an opportunity to review this plea form or go over it with Ms. George?
No.
Okay.
Okay, have just a moment, Your Honor.
Sir, do you understand that by entering into this plea today, that you're giving up your right to have a trial by a jury?
Yes.
Do you understand that you will not be able to present any witnesses, evidence, or defenses on your own behalf?
Yes.
You are giving up the right to make the state of Florida prove that you are guilty beyond a reasonable doubt. Do you understand that? Okay, so this case will be over today. Okay. I'm going to, at this time, ask you, sir, whether or not you're under the influence of any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today.
No, not at all.
All right. Are you on probation?
No.
Do you understand, if you are not a U.S. citizen, that this plea will result in your deportation?
It may, yes,
You understand?
yes.
Okay. I'll
May.
accept your plea, adjudicate you guilty, sentence you to 13 days in the county jail with credit for 13 days time served. You'll have to pay court costs. Those will be due 1 year from today, or you need to see the clerk of the court for a payment plan. I'll take no action on the out on bond case. Thank you, sir.
Can we settle for the new charge?
No.
Can we do anything with it?
Your bond on that's $2,500.
Okay. All right, thank you.
Mr. Felix? Mr. Felix, this is 23 CF 4544. You were arrested for fleeing and eluding and possession of a firearm by a convicted felon. There is probable cause. I am going to appoint the public defender to represent you. All right, Mr. Felix, your bond on count 1 is gonna be $2,500. Your bond on count 2 is going to be $150. You are not to possess any weapons or firearms, and you are not to drive without a valid driver's license. Thank you, sir.
It's history if you guys.
Yeah.
I didn't have it. I
have
just didn't know.
history If you needed it, Your Honor, anytime.
Oh.
If it has that, if it was early and you're happening this
Okay.
week also here,
I appreciate that.
I can cite the history too.
Okay, thank you. Mr. Gonzalez? Is that you? This is 23 CF 4545. You were arrested for burglary of a structure, possession of methamphetamine, and possession of burglary tools. There is probable cause. I'll appoint the public defender to represent you. Your bond on count 1 is $5,000. Your bond on count 2 is $150. Your bond on count 3 is $150. You are not to return to the scene or have any contact with any of the victims. Thank you, sir. Mr. Grice?
How you doing?
Mr. Grice, sir, you are here in 23 CF 4508. You were arrested for carrying a concealed firearm and possession of MDMA. There's probable cause. I'll appoint the public defender to represent you, sir. Your bond on count 1 is $150. Your bond on count 2 is $1,000. Thank you, sir. Hey, Mr. Hill?
Yes.
Hi, Mr. Hill. This is 23 CF 4534. You were arrested for 2 counts of battering a law enforcement officer and resisting officer with violence. There is probable cause. I'll appoint the public defender to represent you. Your bond on count 1 is $1,500. Your bond on count 2 is $150. Your bond on count 3 is $150, sir. You're not to possess any weapons or firearms. Thank you. Sir, are you Mr. Care?
Yes, ma'am.
Did I say that correctly?
You did.
Okay. This is 23 CF 4537. You were arrested for grand theft. There is probable cause. I will appoint the public defender to represent you. You're not to return to the Walmart. Your bond is $1,000, and then you have an out-of-county warrant out of Polk County for failing to appear on a felony domestic battery case. That bond is set at none. If you post your Orange County bond, Polk County will then come and pick you up. Otherwise, they won't come and get you until you resolve your Orange County case.
Okay.
All right? Thank you, sir.
Medina?
Mm-hmm. Mr. Puig?
Yes.
Mr. Puig, this is 23 CF 4526, 23 CF 4527, and 23 CF 86. You were arrested, that one is pursuant to a probable cause warrant for sale and delivery of fentanyl. The bond on it is $1,500. The other two are for possession of cocaine. There is probable cause. I'm going to appoint the public defender to represent you in all of the cases. Sir, I'm gonna release you on your own recognizance as to the two cases, 4526 and 4527. You're not to possess or consume any controlled substances without a valid prescription, and you must appear at all your court dates. Thank you, sir. Mr. Keone Santiago? All right, sir, this is 23 CF 4524. You were arrested for possession of fentanyl and possession of cocaine.
Your Honor, as to the cocaine, I believe, just trying to double check because I'm an off all today. I didn't see any PC for the cocaine. I do not believe that Mr. Quiones was the owner of the vehicle, and it appears that it was in the center console.
Mr. That's why I was releasing them ROR. I
Oh,
don't
okay.
know who had what where.
Okay, I just wanted
know
to
it was
make-
all in the car. So,
Mhm.
I do think there's probable cause for the arrest. But I don't, like I said, I don't know in terms of
Your Honor,
later on.
The fentanyl was in a bag with his ID on it. The cocaine was in a center console that would be a constructed position. However, I believe the fentanyl was located in a bag with a driver's license bearing his name.
That's correct. I underlined that sentence. Okay, so bond on count one is $1,000. Bond on count two, again, there's probable cause, but I'm gonna, ROR him as to count two. Do not possess or consume any controlled substances or, alcohol without a valid prescription, and you can't return to the scene.
Excuse me, ma'am.
Yes, sir.
Is there any, can you please give me all on count two too? I don't get paid till next Friday. And you know, I got a job out there.
What do you do?
I do plumbing. With Mr. Carlos.
You live here in Orlando?
Sure.
Your family live here?
I'm by myself. Family live in Boston, Massachusetts.
How long have you been here?
I've been here about 6-7 years.
Okay.
Family, my mom is dad. Last year, my little brothers went up north to Boston with their dad's sister. I'm out here by myself. I'm out here with my baby mom lives out here. But me and her not together, so it's just me. I'm out here, you know, trying to do right for my daughter.
All right, you're gonna go to your court date?
Yes, sir. I promise you.
Okay. All right, sir, I'll release you on your own recognizance. You have to stay in touch with your attorney. You can't use any drugs, and you have to appear at your court date. Do you understand me?
Yes, ma'am.
Okay, thank you.
Thank you.
There's just two. You want to waive, Ms. George?
I will waive, Your Honor. I just didn't have any PC for providing false ID to law enforcement. I do not believe, I believe in the affidavit, he didn't state anything.
Your Honor, state has no objection. Usually when they refuse to speak to law enforcement, they file the resisting without,
Resisting,
which
yeah.
was already filed by the officer, so they would ask for ROR on 3.
Okay, so that's 23 CF 4541. I'll appoint the public defender to represent Mr. Romer, and she has waived his appearance. The court finds probable cause for counts 1 and 2. He will be ROR'd as to count 3 as there's no probable cause. Bond on count 1 is $3,500. Bond on count 2 is $100. He's not to possess any weapons or firearms or have any contact with the victim. Right. Mr. Stevens, or Ms. Stevens?
And so waive, Your Honor.
This is 23 CF 4510. I have appointed the public defender to represent Ms. Stevens. There is probable cause for possession of fentanyl and possession of drug paraphernalia. You said she's on medical? So I'm going to release her on her own recognizance. She is to keep in contact with the public defender and appear at her court dates. Do not possess or consume any controlled substances without a valid license or valid prescription. Swanson? Okay, I will find a waiver of his appearance based upon his refusal to come to court. 23 CF 4533, I will appoint the public defender to represent him. Bond on count 1 is 1,000, bond on count 2 is 100. Mr. Torres? Mr. Torres, this is 23 CF 4525. You were arrested for possession of cocaine. There's probable cause. I'm going to appoint the public defender to represent you. I'm going to release you on your own recognizance at this time. You are not to possess or consume any controlled substances without a valid prescription. You must appear at all court dates and keep in contact with your attorney, sir. Okay? Thank you. Mr. Williams? All right, Mr. Williams, this is 23 CF 4515. You were arrested for aggravated assault with a firearm and using a firearm under the influence of alcohol. There is probable cause. I'll appoint the public defender to represent you. You are not to have any contact with the victim. You're not to possess any weapons or firearms. Bond on count 1 is going to be $2,500. Bond on count 2 is going to be $100.
Your Honor, we just asked for a no return to the victim's residence.
Sir, you also cannot return to the scene 5158 East Winds Drive. Okay, thank you. Ms. Wilson? Hi. Good afternoon, ma'am. This is 23 CF 4529. You were arrested for aggravated assault with a firearm and unlawful discharge. There is probable cause. I'm going to appoint the public defender to represent you. Ma'am, you are not to have any contact with any of the victims. You are not to return to the scene. You are not to possess any weapons or firearms.
Okay, but
And Your Honor, DCF was also contacted.
Okay.
she states that she currently resides there, Your Honor.
I believe it was
The victim living there as well?
her house where the victim showed up due to instructions allegedly from the defendant to come by.
Okay. I will remove that condition. So ma'am, you're not to have any contact with the alleged victims. You are not to possess any weapons or firearms. Do you have any additional firearms in the home? No? Okay. And then you will need to comply with any DCF requests and the investigation. Do you have any questions about that? All right, Ms. Williams, or Ms. Wilson, your bond on count 1 is going to be 2,500. Your bond on count 2 is 100. Thank you, ma'am. And court will be adjourned.
I don't think she got what she was.
Good morning, Your Honor. This is Christopher Vanscoy, Spanish interpreter, previously sworn. Hi, good morning. This is Judge Martha Adams. I'm out at the Booking and Release Center. We are here on case number 2023 MM 239780. The defendant's name is Osmany, Osmany, Duany, Duany. And Mr. Duany, do you need the services of the interpreter? You do not, okay. And so then in the witness box, I'm assuming that this is Ms. Quintero? Okay, okay,
¿Es usted la señora Quintero?
okay.
Yes.
Ms. Quintero, he's on the speaker.
Señora Quintero, la intérprete se encuentra hablando a través de las bocinas.
It's my understanding you need the services of the interpreter. Is this correct?
Yo tengo entendido que usted requiere los servicios del intérprete. ¿Acaso esto es correcto?
Sí, para sentirme más cómoda.
Yes, I would feel more comfortable.
Okay. Well, Ms. Quintero, my job this morning is to determine if there was probable cause to hold the defendant for charges and then also to determine his conditions of release.
Pues señora Quintero, el papel que yo juego es determinar si existen indicios razonables de criminalidad para que el acusado se mantenga encarcelado o si va a ser puesto en libertad.
Normally, in these types of cases, because it is domestic violence and you are the alleged victim, I issue a no contact order.
Normalmente en estas causas de violencia doméstica, yo impongo una orden de prohibición de contacto para las víctimas.
Is that something that you're in agreement with, or were you wanting to have contact with your husband?
¿Acaso esto es algo que usted está de acuerdo o prefiere en vez mantener comunicación con su esposo?
Normalmente hablamos bien. Anoche no sé qué pasó. Tenemos 2 niños y quiero tener una buena relación. Y tenemos 17 años de casados y me gustaría solventar la situación. No quiero solventar el problema, no quiero agrandarlo más.
Well, normally we speak just fine. I don't know what happened last night. We have 2 kids and we have a good relationship. We've been married for 17 years and I want this fixed. I don't want this to get any worse.
Lo que pasa es que anoche me asusté muchísimo, porque nunca lo vi tan agresivo así y temía que pasara algo más, y por eso pedí la protección, porque no me sentía segura.
Well, last night I was just very, very, very scared. I had never seen him so aggressive and I was afraid. I was afraid. And that's why I asked for protection because I didn't feel safe.
Okay. Well, if I allow him to come back home, are you going to continue to feel unsafe? Or do you think that now that this has happened, that maybe he's calmed down? Or do you think he's more angry?
Bueno, y si yo le permito a él regresar a la casa, ¿se sentiría usted a salvo con eso? Porque ya que ha pasado esto, es posible que ya él se haya calmado o tal vez se sienta más con coraje debido a esto.
Sí, están las 2 probabilidades.
Yeah, they're both a possibility.
Pero me gustaría, si queremos tener una buena relación por nuestros hijos y tantos años, buscar como un consejero y no de una apartarnos así sin darnos la oportunidad de poder solventar esta situación con un intermediario, ya que vemos que no nos entendemos
But what I want is to have a good relationship for our kids, for the sake of our marriage. Perhaps maybe some counseling, because I don't want to drift apart with my husband without at least having the chance to mediate the situation with a third party.
So, ma'am, I certainly understand, but you have to understand, I'm not a therapist. I can only control the situation in the sense of uh, determining what conditions of release you and your husband have.
Bueno, señora, yo la entiendo, pero usted me tiene que entender a mí que yo no soy terapista y yo solamente puedo controlar las condiciones de si es puesto en libertad o no.
If you think that you're going to be unsafe with him, I can make him live someplace else, and the two of you can then work on your relationship as it progresses. Would you like me to continue that?
Señora, si usted cree que no va a estar segura, yo le puedo imponer condiciones a él de que vive en otro lugar y entonces pueden así tratar de solucionar los problemas en su matrimonio. ¿Crees que eso es una alternativa que le parece bien?
Sí, es una posibilidad.
Yes, it's a possibility.
Okay. Well, what I'm going to do is order, I do find that there's probable cause. I will go ahead and appoint the public defender's office to represent Mr. Dwani, and I'm going to set his bond in the amount of $500. The conditions are that he, at this time, he's not to have any contact with you. That means he's not going to be able to see you, call you, text you, email you, have any contact with you through a third party. The only time that contact will be allowed is if you're in court with him. So if in the future that you do want to change that, or you figure out somebody that can maybe be a counselor, you can certainly ask the judge to change this condition.
One moment, Your Honor.
Sure.
Bueno, señora, entonces yo voy a imponer la siguiente orden. Yo determino que existen suficientes indicios razonables de criminalidad, por lo tanto, le voy a designar la oficina del defensor público al señor Duani. Voy a imponer fianza en la cantidad de $500. Le prohíbo a él que se comunique contigo, ya sea verle, llamarle, enviarle mensaje de texto, correo electrónico. Tampoco se puede comunicar con usted con ninguna tercera parte. Y en el futuro, si usted desea cambiar estas condiciones, usted le puede solicitar ante un juzgado, ante el tribunal, para que se cambien estas condiciones y pueda comunicarse con usted.
I will allow him to return one time to your residence so that he can retrieve any belongings that he needs, but that will be with law enforcement officers.
Le voy a permitir que regrese al hogar en una sola ocasión, escoltado por los agentes del orden público para que él pueda recoger sus pertenencias.
I'm also going to order that he not possess any weapons or firearms.
También le voy a ordenar que se le va a prohibir la posesión de algún tipo de armas o armas de fuego.
And is there anything else that you wanted to let me know?
¿Acaso hay algo más que usted desea dejarme saber?
Sí, tenemos dos niños. Y ellos aman
Yes, we have 2 kids,
ellos aman a su papá.
and they love their father.
¿Hay alguna posibilidad que él pueda ver los niños y pueda ir, aunque sea una vez a la semana a la casa con los nenes? Y es que es duro.
Well, I mean, it's tough. Is there any possibility that he could go see the kids at least, once a week to go see the kids?
That's entirely up to you. Because I have the no contact order between the two of you, and you're you have your children, it's hard for me to force you to have contact with him just because of the children.
Bueno, esa decisión le corresponde a usted porque ya yo impuse una orden de prohibición de contacto y yo sé que ustedes tienen hijos, así que la decisión le va a corresponder a usted si usted quiere que él vea a los niños o no.
It's,
Honor?
hold on one second. It's my understanding that his mother lives here in town. Do you have a good relationship with his mother?
Bueno, yo tengo entendido que su mamá vive aquí en la ciudad. Le pregunto a usted, ¿acaso tiene una buena relación con la mamá de él?
Sí, sí, tengo.
Yes, yes, I do.
Would you be comfortable if the children, if you wanted him to see the kids, they could go and stay with his mother and then he can see them? Because I have a feeling he may end up having to stay with his mother.
That's what I was gonna ask.
No, yo tengo un sentimiento de que él va a tener que quedarse con su mamá, así que le pregunto, ¿se sentiría cómoda usted de que los niños se queden con la mamá de él para que entonces él así los pueda ver a ellos?
Uf, es que normalmente tenemos 17 años y él nunca han visto a su papá fuera de casa y para verlo a él. Es algo
Well, the
que
thing is, it's been 17 years, so they have never not seen their father before.
No, and I'm more concerned about you. What I'm just asking is if you are okay, if he lives with his mother, would you be okay with taking your children to his mother's house? And then that way he could see them there. You don't have to see them, but you could let the children be dropped off there.
Mi preocupación es usted, señora. Quiero saber si usted se siente cómoda porque él no asegura va a vivir con su mamá. ¿Se siente usted cómoda llevando a los niños a la casa de la mamá para que él entonces así los pueda ver a ellos? Usted no lo tiene que ver a él.
sí me siento cómoda que los niños vayan para allá y eso, pero lo difícil es poner en situación los niños en que se tienen que ir a casa de la abuela a ver a su papá. Es bien difícil.
Well, yeah, I do feel okay that the kids go, but the hard part is, placing the kids in the middle of all this and having them go to their grandmother's house just to see him.
I agree, but your safety and the safety of your children is what I'm most concerned about.
Yo estoy de acuerdo con usted, señora, pero lo más que a mí me preocupa es su seguridad y la seguridad de los menores.
If you have some other suggestion as to how you think this should work, I will gladly ask.
Ahora, si usted tiene alguna otra alternativa que cree que funcionaría, pues me lo tiene que dejar saber.
¿Hay alguna manera de que Osmani pueda decir de verdad sus sentimientos a la situación ahorita, de lo que piensa, y podemos hacer un poquito más flexible, no tan drástico completamente, sacarlo de la casa por un error que tuvo anoche?
Señora, permítame. Is there any way that Osmani can express how he's feeling about the whole situation and not, resort to such drastic measures?
Your Honor, so that was the suggestion my client had, was that his mom could facilitate the third-party visitation at this time, because that's probably where he's going to have to reside anyway. That would be the only thing we would ask for.
Su señoría, lo único que vamos a solicitar, mi defendido también me lo indicó, que él cree que lo mejor sería de que su mamá actúe como una tercera parte en esto para que él pueda visitar a los nenes, porque lo más seguro él se va a quedar con ella.
So, ma'am, it's my understanding that that was your husband's suggestion as well, was to use his mother as a third party.
Pues señora, entonces yo tengo entendido que su esposo también sugirió la alternativa de utilizar a su mamá, a la mamá de él, como una tercera parte.
I certainly understand that this is not the most perfect situation, but it is not necessarily permanent. It can be temporary. The state will definitely be reaching out to you. And if there is something at any time you want to change, you can get with them and let them know.
Otra cosa,
Entonces, señora, yo entiendo que esto es una situación perfecta, pero tampoco es permanente. Esto es provisional. La fiscalía se estaría comunicando con usted y si usted desea algunos cambios, pues se le podrá conceder.
eh, otra, otra, otro punto que me preocupa en esta situación, porque desde que yo tuve los niños, yo estoy con ellos y yo no trabajo, yo no tengo forma económica de lo que es para poder, normalmente Osmani, mi esposo, él trabaja, se va a trabajar fuera del estado por bastante tiempo y yo me he quedado con los niños y él normalmente cubre las necesidades de todo. Entonces ahora, con esta situación, esa es otra parte que me preocupa, porque normalmente los niños están en un nivel de vida que están felices, saludables, comen bien, hacen sus actividades. Entonces, cambiarle de un momento a otro su rutina me preocuparía mucho.
Un momento, señora, por favor.
Disculpe.
And the other point I would like to make is since I had the kids, I haven't been working, so I have no means to, well, my husband, he works out of state and he covers all of our needs. And with this situation, that's my other concern because the kids are used to a lifestyle, they're happy, they're healthy, they do activities, they eat well. And this sudden change in their routine, I really feel like it would affect them greatly.
I do not disagree with you at all. But, ma'am, as I said, I'm not a therapist. I can only induce conditions that are to keep you and your family safe. Right now, you're telling me that you're concerned about your safety, so I'm going to keep this no contact order in place. He's going to be able to get out. I want him.
Señora,
Go ahead.
señora, él va a ser puesto en libertad y yo no estoy en desacuerdo con usted, señora. Yo le dije anteriormente que yo no soy una terapista, no soy una aconsejadora, por lo tanto, mi preocupación es mantener a usted y a sus niños a salvo.
Yo entiendo esa parte, pero la que le estoy tocando es la parte económica.
I understand that part. I'm just touching on the economical aspect of it all.
And I understand there's that aspect as well. You may want to consult an attorney about what options you have, but until the time that you want it to change between you and your husband, I'm going to keep the no contact order.
Señora, y yo entiendo eso, yo entiendo ese punto, pero tal vez usted lo que desea hacer es consultar con un abogado, a menos que usted quiera algún cambio en la orden de protección. Pues en este momento impuse una orden de no contacto, a menos que usted desee hacer unos cambios.
So I will allow his mother, the children's grandmother, to be the intermediary between you and your husband so that you can discuss him seeing his children until you decide otherwise.
Entonces, señora, a menos que usted cambie de parecer, yo le voy a permitir a su mamá, a la abuela de los menores, que juegue el papel de la intermediaria de la tercera parte.
Okay?
Bien.
Normalmente no me gustaría poder tener porque intermediario la abuela, ella va a estar más cerca de su hijo, claro, ¿entiende?
Well, normally what I would want is, the grandmother, yeah, she's gonna be, siding with her son. She's gonna be closer to her son.
Sí, y eh,
I understand. Do you have any family members here that you would feel comfortable?
Bueno, eso lo entiendo. Le pregunto, ¿tiene usted algunos familiares aquí con la cual se sentiría cómoda?
Eh, lo que, lo que no sé si me estoy explicando bien.
I don't know if I myself be clear.
Yo sé que usted me quiere mantener segura, safe, y le agradezco mucho esa parte. Lo que me preocupa, cómo se podría arreglar la parte monetaria, económica, de yo tener la mensualidad que normalmente mi esposo usualmente nos da para mantenernos, porque esto de un momento a otro yo no tengo ningún ahorro, las cuentas nosotros son separadas y de un día para otro todo cambia y yo estoy en el aire.
Well, the thing is that this change is sudden and I don't want to be left hanging. I know that you want to keep me safe and I thank you so much for that. But my biggest concern is I want to address the part about the economical aspect. I have monthly income that my husband provides for us and I don't have any savings and our bank accounts are separate.
Ma'am, I can't fix 17 years worth of marriage in 10 minutes. I don't have the ability to do that. What you need is to figure out what you want in your life, whether that means continuing to be with your husband or divorcing him. Right now, my only goal is to make sure that he's entitled to a bond, which he is, and make sure that you and your children are safe. You're telling me that you do not feel safe with him having contact with you. My only ability is to issue a no contact order.
One moment, Your Honor.
Yes.
Señora, yo no puedo arreglar 17 años de matrimonio en 10 minutos. Usted tiene que decidir qué es lo que quiere. Usted puede continuar casada con él o pueden en vez radicar una solicitud de divorcio. Mi meta es que él tenga una fianza y él tiene derecho a ella. Y yo lo que quiero es que usted y los menores estén seguros. Usted me ha dicho a mí que no se siente segura. Por lo tanto, lo que yo puedo hacer es emitir la orden de prohibir contacto con usted.
I don't know what else to tell you. I'm going to tell you that I'm sorry. I've taken up enough time that I can. If you want this to change, like I said, you have the ability to reach out to the state attorney's office and ask them to change it. But until you feel safe, this is what I'm going to do.
Señora, y yo no sé qué más puedo decirle. Ya hemos tomado suficiente tiempo con esto. Si usted desea cambiar esto, se puede comunicar con la oficina de la fiscalía y pedir que se cambie o que se modifique.
La entiendo y gracias.
I understand and thank you.
Es que me siento bien preocupada por mis niños y su bienestar también.
I'm very worried for my kids and their emotional well-being.
And I'm sorry that your husband has put you in this position and that he's put your children in this position. Hopefully, all of this in a few days will have all worked out and it'll move on. But until that time, I need to keep you safe.
Señora, y yo lamento mucho de que su esposo la haya puesto a usted y a sus hijos en esta posición, pero yo espero que de aquí a unos días esto se pueda resolver. Pero hasta que llegue ese momento, la tengo que mantener a ustedes seguros.
¿Está bien?
¿Le parece? ¿Está bien?
Sí, tengo el corazón roto.
Yes, my heart is broken. It's not easy.
I understand. Lo siento. Okay. Thank you, sir. Good luck. Okay, let me just get, that was the only Spanish case today, I believe. So thank you.
You're welcome, Your Honor. That was long. I'll see ya.
Have a great day. Thank you.
You too.
Okay, the next case I have is Rose Darlene Laros.
Yes, ma'am.
And you speak Creole?
Yes.
Do you speak English?
No, but I can listen a little bit.
Okay, we're gonna get you an interpreter.
Okay.
Hi, good morning.
Good morning. My name is Marcel. I'm the interpreter.
Good morning, Martel. My name is Martha Adams. I am the judge that's presiding over our initial appearances. With me this morning is Rose Darlene LaRose, and it's my understanding she speaks Haitian Creole. Have you been sworn in today?
Not yet, Your Honor.
Do you, if you could, just raise your right hand. Do you swear that you will translate from English to Haitian Creole and Haitian Creole to English to the best of your ability?
I do.
Okay, thank you. So
welcome.
we'll begin. Ms. LaRose, you're here on a criminal charge of battery domestic violence.
Miss La Rose, ou la jodi a charge qui gagne contre moi, c'est bat moun, c'est une violence domestique, violence dans caille.
Without your boyfriend and the father of your child being present here this morning, I do have to issue a no contact order between the two of you.
Et jodi a ménage ou li pas là, m'a obligé par son l'ordre que pour nous tous deux nous pas prendre contact l'un à l'autre.
Now, the officer is having you sign that piece of paper. That's just acknowledging that you've been told about the no contact.
Officier tribunal là, la bon signé papier, un papier là, et papier ça le dit que ou au courant et non dit qu'on pas supposé prendre contact à moun.
That no contact order does not have to be permanent, but the only person that can change it after today is Judge McGinnis, the trial judge.
Contact, ça nous dit là, il pas obligé permanent qu'on pas prendre contact à moun nan, mais seul monde qui est capable de changer ça, c'est juge McGinnis.
So, ma'am, what I'm going to do is I will appoint the public defender's office to represent you.
Ma poil mettre un avocat de la défense publique pour défendre.
I am going to set your bond in the amount of $500.
Moi poil mettre un caution pour capable sortir de $500.
When you got arrested last night, were your children still with your boyfriend?
Les yo arrêté hier soir, et ce petit moun yo, c'est avec ménage ou sécurité.
Oui, il t'a dormi.
Yes, he was sleeping.
Okay. So right now, because DCF is involved, you will need to abide by any plan they put into place.
Donc, le fait que DCS, dans cas coulier, il y a des règlements que vous pouvez ba ou obligé respecter règlement ça.
I am going to order that you maintain a separate residence from Mr. Manuel.
On va ordonner tout que vous êtes on l'autre côté, comparé même côté avec monsieur Manuel.
If you need to return home and he is still there, you may retrieve your belongings with law enforcement officers one time.
Si ou gen bagay ou nan kay la toujou, e ke M. Manuel nan kay la jist pou li ya, seul jan wap kapab pran yo, se pou retourner avec un policier, un moun ki nan la loi, se seul jan kapab pran yo, ou kapab tourner un gren fois.
I'm also going to order that you not possess any weapons or firearms.
Et n'a demandé tout qu'on pas supposé gagner aucune arme sous ou pas doit gagner aucune arme à feu sous.
That piece of paper, the green one, is the phone number for your attorney. If you want any of these conditions to change or think they need to change, you can contact them and they can get you in front of the trial judge.
Mon papier vet ça m'a ou là, c'est la donne qui a numéro avocat pour le défendre yo. Si gen ken bagay ou vle changer ou a parler avec yo et puis le ça, il y a le code juge qui va le faire jugement et amender pour changement fait.
Because of the no contact order, it is possible that you will not be able to see your children until DCF and the trial judge have told you otherwise.
À cause de l'autre que vous passez qu'on doit prendre contact avec moun nan, ou capable pas kaweti moun yo pas avant que DCS dit qu'on gagne droit et pas avant que DCS fait des arrangements pour ça.
Was that your question?
Et c'est ça question on dit. Pardon?
Juste le petit point.
I need my child.
And I understand that. And that's why I said this is not permanent, but without Mr. Manuel being here, this is what I am forced to do.
Moi comprendre ça et c'est peut-être ça me dit que l'autre moi là pas permanent, mais comme monsieur Manuel pas là, koulia là, m'obligé faire bagay yo dans sens ça.
Okay? I'm sorry. I know it's not what you want to hear.
Moi bien désolé, me connais pas ça t'avais tendé.
But talk to your attorney at that phone number and
Parler avec avocat là dans numéro ça.
and they can see about changing the conditions once they've maybe been able to talk to your boyfriend.
Et peut-être le ça, l'on parle avec avocat, yo cap chercher un gens pour changer conditions yo, après que yo fin parler avec ménage.
Okay?
D'accord?
Merci. Thank you.
Thank you. Merci.
Okay, thank you, sir. That was everything for this morning. I appreciate your help.
You're welcome and thank you very much for using our services.
Thank you. Goodbye.
You're welcome. Bye-bye.
Yes. Miss Blinn? Yes, ma'am. Okay, I will go ahead. She's an out-of-county warrant with a no bond.
I'll waive, Your Honor.
Yeah, let's just waive. It's out of Seminole, and then that way Seminole can come and pick her up. Okay, thank you. Okay, good morning, sir. This is James John Perez. Yes. Okay, Mr. Perez, you're here on case number 2023 CF 4549AO, and Mr. Moses, you're here on behalf of Mr. Perez, correct?
Yes, Your Honor.
Okay, so I did review the charging affidavit. I am finding that there's probable cause. My intent was to just give him a $5,000 bond on count one and then give him the 150 or the 100s based on that. But I did not see that the victim was here, so give me 1 second. This is Kiara, is it Ben Cosme? And Miss Ben Cosme, so you've obviously been listening this morning. Actually, let me do this. Can I get you to raise your right hand for me? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. And Ms. Ben Cosme, as you've heard, I normally do issue no contact orders between the two of you unless you feel otherwise. What would you like to have happen?
We can have contact.
You would like to have contact with him? So what I'd be willing to do is issue a no hostile contact. That means you guys can see each other, but just no fighting, no arguing, nothing like that. Do you think you'll be safe with that?
Yes.
Okay. Mr. Moses, so I would just do the straight bonds with the no hostile contact and no firearms or weapons. I do believe DCF was contacted, so he would just need to abide by any plan. Was there any, is that okay with you, or did you want to argue for something
No,
different?
no, that's perfectly fine. I wasn't aware of DCF, but I'll make sure that he understands that if there's any plan that's in place, he must abide by that.
I think if I looked,
They were, Your Honor.
It was a
were
two-page affidavit. I may have missed that part.
yeah, it felt, most of these affidavits felt like I was reading novels this morning. So, Mr. Perez, what I'll do is I will set your bond at $5,000 on count one. It'll be 150 on count two, 150 on count three, 150 on count four, 150 on count five, 150 on count six, $100 on count seven, and $100 on count eight. I'm going to order that you have no hostile contact with your girlfriend, and that you not possess any weapons or firearms, and that you just abide by any plan that DCF may put in place. Did you have any questions? No? Ma'am, did you have any questions?
No.
Okay, you're all set then. Thank you so much.
Thank you, Your Honor. Good seeing you.
Thank you. Good to see you too. Take care.
You too.
Okay. Hi, good morning, sir. Are you Terrence Andy Smith? Nope.
I refuse, Your Honor.
You refuse. Okay, no worries. I will go ahead and waive Mr., well, I can't waive his appearance, just the PD.
Yes, Your Honor.
Thank you so much. So we'll go ahead and waive Mr. Smith's appearance. It is a warrant out of Polk County. He does have a $1,000 bond. How about, are you Toy Nathaniel Valentine?
Yes, ma'am.
Okay, wonderful. So it looks like, and you guys can correct me if I'm wrong, this is case number 2023 CF 449080. It's out of Division 17.
This was a reset over the weekend due to not finding PC. State was not able to obtain an additional affidavit, but just does have additional just argument. For the crime of a burglary, which Mr. Valentine is charged with, either entered a structure or conveyance owned by the person and had the intent to commit an offense therein within said structure. Within this affidavit, it states that he entered the house. There's many parts throughout this saying that he was within the house when law enforcement arrived, that there was a crime therein of theft and also criminal mischief. I believe there's alleged damage of the amount of $1,000. There's a missing air conditioner of $1,000, damage to the door of $650, as he allegedly entered the rear door by kicking and breaking the deadbolt to enter the house. And I believe he was sleeping inside the residence when the alleged owner came to check on the alleged residence. So they would argue that the defendant entered the residence owned by this other person, and there was an intent to commit a crime therein, as there was theft of multiple items and criminal mischief, as many items were broken.
I'm sure that Mr. Valentine was definitely here when Judge Weiss heard this, but were either of you here when Judge Weiss?
It's not.
I was not, Your Honor. All I know is the state was to provide an additional supplement, and they did not. So I would ask for ROR. I'm not sure.
Your Honor, as defense often argues, PC is ongoing.
Well, and unfortunately, I apologize, but I don't necessarily see what Judge Weiss or what whoever brought up this argument. I agree with the state. There's clearly evidence that the defendant was in the home. Home was not belonged to him. And not only was there an allegation of criminal mischief, but also of theft that's backed by the statements in here. So I do think the crime of burglary was met. So I am going to find that there's probable cause. That's in the 2023 CF 449080. The Public Defender's Office was appointed. I'll keep the bond set at $5,000. Since Mr. Valentine seems to be so happy about that, I'll go ahead and revoke the bond in case number 2022 CF 1397680. I'll appoint the Public Defender's Office if they weren't previously appointed. It looks like he was possibly also out on trial or out on bond in case number 2023 MM 200280. Oh, that was an ROR. I'll revoke the ROR and set the bond at none.
Are there any conditions, Your Honor, on the new law?
On the original charge, no return and no contact with the victim, though I don't know that that would be an issue. Okay, good morning, sir. Are you Brandon Battles?
Yes, ma'am.
Okay, Mr. Battles, you are here on case number 2023 CF 453080. Give me 1 second just to grab paperwork. Okay. And Mr. Battles, I did review the charging affidavit in this case. I am finding that there's probable cause. You need to understand that without Miss, I'm probably gonna butcher her last name, Lubunov, without her being present here this morning, I do have to issue a no contact order between the two of you. That being said, I am gonna set your bond in the amount of $2,500. The no contact order will remain in place. That means that's between you and the victim. I am gonna order that you maintain a separate residence from her. If there are any belongings that you need to retrieve at your home with her, you may do so one time with law enforcement officers. You are also not to possess any weapons or firearms. Okay, you're all set. Good luck, sir. Thank you.
I'm sorry, Your Honor, what was the bond amount?
2,500. Okay, good morning, sir. Are you Julian Beltran?
You said what?
Are you Julian Beltran? Okay. Sir, I have you here on a couple of cases. I found 4. The first case I had was the 2023 MM 238780. I did find probable cause for a battery charge without the victim being present here today. I do have to issue a no contact order between the two of you. That no contact order will remain in effect. You're just signing a piece of paper that says that you're acknowledging that you've been told about the no contact order. It is not necessarily permanent. Judge McGinnis, the trial judge, has the ability to change that, but he's the only one that can do that. So I am going to order that you maintain a separate residence from her. If you need to retrieve any belongings, you may do so one time with law enforcement officers, and you're not to possess any weapons or firearms. There is another charge of 2023 CF 4542AO. This was the burglary of conveyance and petty theft charge. I am going to set your bond at $3,500 on count 1. Count 2, I will reduce to $100, and I'll keep that at that, and appoint the public defender's office. There is the felony charge, 2023 CF 4518AO. This is in regards to the firearm and the drugs alleged to be present when you were arrested. I am finding probable cause. I'll appoint the public defender's office to represent you. I'll go ahead and keep your bond set at $1,000 on count 1. Count 2, I will reduce to $150. Count 3, I will keep at $7,500. Count 4, I will reduce to $150. Count 5 will be $150, and count 6 will be reduced to $100. The public defender's office is appointed to represent you. On the warrant that was outstanding in case number 2023 CF 3379AO, that was a warrant that was signed by Judge Egan in March. He did set your bond at $5,000 and order that you have no contact with the victim in that case. It is a grand theft. I will go ahead and appoint the public defender's office to represent you. Now, sir, because you are currently out on bond in case number 2023 CF 801AO, I am going to revoke that bond. That's in Division 20. I'm sure the public defender's office will reach out to Ms. Altawam so she can see if they can get you back in front of the trial judge to see if you're entitled to a bond after that. Okay, good luck to you, sir. Thank you. Is this Ruth? Is it Exelase?
Yes, Your Honor.
Did I say that properly? Okay. And Ms. Exelase, you are here on case number 2023 CF 4536AO. I'm going to assume these are your family members that are in the box. Can I have the two of you raise your right hand for me? Do you both swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. And can you tell me both of your names?
I'm Claysimon Francois. And I'm Christina Exelis.
Okay. And so I had Christina and Clues.
Claysimon.
Say it one more time.
Claysimon.
Claysimon?
Claysimon.
Okay. And it's my understanding you're her sisters, correct?
Yes.
Okay. And what I gathered from the charging affidavit is she no longer lives with you. You live with your mother at your home, and she came to the home. So you obviously know that what I've done in the past is issued these no contact orders so that she would not be able to return. Is that what you would like for me to do, or did you want me to do something differently?
We want her to return back to the house. It was an argument that just escalated and just got out of hand, to be honest. And so my mom couldn't be here because she had a heart appointment, but our wish is for her to come back to the house. She doesn't have a place to go. My sister's leaving, and I will make arrangements to move out afterwards, so that way won't cause any issues in the future.
Okay.
Can she be RR'd under the conditions of no weapons and no hostile contact? Like my sister said, I'll be moving out tomorrow, so I won't have any contact with her, and then my sister will be moving out soon, so it'll just be her and my mom at the house.
Let me inquire from the state. Let me first say what I will do is definitely, as far as I'll allow her to return home, the only thing I would do is issue a no hostile contact, like you said. Does the state have any objection to an ROR if I provide those conditions? It does not appear that she has any criminal history.
Your Honor, it doesn't appear she has any other criminal history. However, state is concerned regarding that there were allegedly 2 weapons that Exelasi picked up. I believe the first was a chair, which she was disarmed, and then a knife, and she was disarmed. So state is just concerned regarding the use of possibly deadly weapons. So So state would just ask for a lower bond, and that she has little to no history.
And she's not gonna qualify for pretrial release. I would assume the two of you are gonna be the ones that would have to post her bond, is that correct?
Correct.
The state's concerned about the weapon issue because she, obviously, as you heard, she did pick up some things. Are you concerned about? So Ruth you're 34? Okay, who's the oldest? You. And I don't mean to ask, but how old are you?
41.
Okay. Have there been issues like this ongoing throughout her whole life, or is this just something that just kind of got out of hand yesterday?
It was just the first time. Like,
Okay.
it got out of hand. And that's why I said it, it was just an argument, and that just escalated to where it got to, yeah.
Okay.
And we won't be there, so, I mean, the weapons won't be of concern because she won't have access
To us.
to us to use anything.
Right, right. I'll go ahead, I'll note the state's objections and their concerns, but based on what the family is telling me, I'll go ahead and release you on a straight ROR. But ma'am, he's just gonna take your ID to write that information down. I am getting you a public defender. But Ruth, my biggest concern is that you need to make sure that you show up to court all the time when your attorney needs you to. Because if they revoke your ROR, it immediately pushes both of the accounts to $2,000 each, which is a $4,000 bond. And I don't think your sisters would be able to pay that for you. So just make sure that you do stay in contact with your attorney. Are you okay going back to your home with your sisters? Yeah, okay, then that's what I'll do then, okay? Good luck, thank you.
Do we stay here for her?
You can talk to the COs, they'll talk to you about when you can pick her up. It may just take a couple hours.
Okay, thank you.
Okay, thank you.
No hostile and no weapons?
No hostile contact and no weapons or firearms. This would be Devin Gonzalez.
Yes, ma'am.
Good morning, Mr. Gonzalez. You're here on 2023 CF 4548AO. This is the case that I did have some issues with. I'll be honest with you, the issues that I had were not so much that it was a robbery, but I kind of looked at it as more of, if you look under the statute for kidnapping, it's where you're using, I got the impression the child was being used almost like a shield. Maybe I read into that too much. I don't know. What was the state's thoughts? I'm assuming the robbery is the child.
The robbery was the phone, Your Honor.
The phone?
It was my phone. I'm sorry.
Okay.
I didn't know.
Well, I still think that there's some issues with him coming out of the house holding the child. That being said, let me look at Mr. Gonzalez's.
I believe his history is mostly driving related or other alcohol related cases.
Yeah. So, Mr. Gonzalez, the main thing is that you understand without Ms. Gray being here this morning, I do have to issue a no contact order. That does mean that that order will remain into effect until the trial judge changes that order. So you're not going to be able to see her, call her, email her, text message her, send her any cards, letters, or gifts. You can't have anyone contact her on your behalf. It's also going to prevent you from seeing your child based on that fact, as well as the fact that DCF was notified and they may be putting into place any plan that goes into effect. So I'm also going to need you to abide by that. Is the state okay with allowing me to give him a bond?
I mean, he's entitled to bond on all of his charges, Your Honor.
Unless one could argue that I found something more, but that's okay. I won't impose myself in that way. So, Mr. Gonzalez, what I'll do is I will, did you want the public defender appointed to represent you, or are you
No,
gonna
ma'am.
hire?
I'll be getting a lawyer.
You're gonna hire your own lawyer? Okay. So I'm gonna go ahead and, I'll do this. I'm gonna set your bond at $7,000 on count 1. I'll do $100 on count 2, $150 on count 3, and $100 on count 4. The no contact order remains in effect. I am going to order that you maintain a separate residence from Miss Gray. If you do need to retrieve any belongings from your home with her, you may do so one time with law enforcement officers. I'm also going to order that you not possess any weapons or firearms and that you abide by any plan that DCF puts into place. Okay? Good luck to you, sir. Thank you. Okay, good morning, sir. Are you Jason Polk?
Yes, good morning.
Okay, good morning, Mr. Polk. You are here on case number 2023 CF4550AO. I believe in the box is Miss Hernandez, is that correct?
Yeah.
Ms. Hernandez, can I get you to raise your right hand? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. So, Ms. Hernandez, I did read the charging affidavit in this case, and I realized that you're the victim. You obviously have heard me talking to the other alleged victims in these cases where I issue a no contact order. Is that what you would like me to do, or are you here to tell me something different?
Yeah, I would like to have contact.
You want to have contact with him? Okay. Okay. And if I issue the no hostile contact, you feel that that would keep you and your children safe?
Yes.
Okay. So I wasn't really sure that there was a battery by strangulation, but I do definitely see a battery, and I do think that the second charge is still a felony. So what I would do is just, I would keep the bond set at, actually, he does qualify for pretrial release.
Yes, Your Honor.
I can do that.
Okay.
Is that okay?
This is one we spoke about earlier.
Oh, okay. So, ma'am, what I'll do, I'll release him on pretrial release. That means that you don't have to pay any monetary amounts to get him out of jail. He will be supervised by pretrial services. It'll just be the condition that he have no hostile contact with you or the children, and that you not possess any weapons or firearms. But it'll be straight PTR on both cases. Do you have any questions?
No.
And Mr. Polk, if I didn't say, I am appointing the public defender if I didn't say that before, okay? Good luck to you, sir. Thank you. Good luck to you, ma'am. Thank you. Hi, good morning, sir. Are you Carlos Popa?
Yes.
Is it Popa?
Opa, yeah.
Popa? And Mr. Popa, you are here on case number 2023 CF4538AO. I did review the charging affidavit in this case. I am finding that there's probable cause. I will go ahead and appoint the public defender's office to represent you. Mr. Popa, this is a little bit unusual because I'm sure you and your wife live at this address in Winter Garden, and your daughter,
Sophia.
Sophia? I have it as Karina?
Oh, Karina, yeah, my big daughter.
Okay. That you had taken her in. So right now, because she is living there and because she's not here this morning, I do have to issue a no contact order between the two of you. That piece of paper that the officer is asking you to sign, just as you acknowledging that you've been made aware of the no contact order. It's not something that has to be permanent, but the only person that would be able to change this order is the trial judge in Division 12. So with it being in place, that means you are gonna have to find someplace else to live until that could change.
She left last night.
She left?
Yeah, she was called by the police also.
Okay, so here's what I'll do. I'll keep the no contact order and I'll just put that you maintain a separate residence from her. And then that way, as long as she's not at the house, you can go back to the house with your wife. And then, he does qualify for pretrial release, so I'll go ahead and release you on a straight PTR so that you don't have to post any money to get out of jail. The only conditions are the no contact between you and your daughter, maintain a separate residence, and no weapons or firearms. Okay, do you have any questions?
Oh, thank you.
Okay, you're very welcome, sir. Good luck to you. Thank you. And I appointed the PD, if I didn't say that. Okay, this is Edwin Ramundi. Is it Ramundi?
Monday.
Ramundi. And Mr. Ramundi, you are here on case number 2023 CF4551AO. I have reviewed the charging affidavit in this case. I am finding that there's probable cause. You understand that without Ms. Baez being present here today, I do have to issue a no contact order between the two of you. The officer is asking you to sign that piece of paper. It's acknowledging that you've been made aware of the no contact order. The no contact order can run you the risk of violating your conditions of release if you have contact with her. That being said, it is not necessarily permanent. The trial judge does have the ability to change it, but he or she is the only one that can do that. Were you wanting me to appoint the public defender's office to represent you, or are you gonna hire your own attorney?
I'm not gonna hire nobody.
You're not gonna hire an attorney? Okay. Well, I'm gonna go ahead, you do qualify for pretrial release, so I'll go ahead and release you on straight pretrial release on all three of the charges. The conditions are that you have no contact with the victim, you maintain a separate residence. If you need to retrieve any belongings, you may do so one time with law enforcement officers, and you're not to possess any weapons or firearms.
I was gonna say, Your Honor, I have my own place, so she was on my property.
Okay, I had,
They provided separate residences.
Yes, we don't live together, nothing. She was in my place.
right, so it's just maintain a separate residence. Okay, so I just didn't know if maybe you had anything at her house. No? Okay, then that won't be an issue for you then. Okay, good luck to you, sir. Thank you. Hi, good morning, sir. Are you Emmanuel Rosario?
Yes.
Okay. Mr. Rosario, you are here on case number 2023 CF4552AO. It's my understanding that this is, hold on one second, Ms. Price, is that correct? And Ms. Price, can I get you to raise your right hand? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, so Ms. Price, I know that you and Mr. Rosario do not live together right now, but as you've heard, I normally do issue no contact orders. Are you in agreement with that, or did you want something different?
I like a no contact order.
You want to keep the no contact order?
Yes, ma'am.
Okay, I just want to make sure you're very soft-spoken, so I just wanted to make sure you're in agreement to keep the no contact order in place.
Yes, ma'am.
And it's my understanding that the children, because they were involved, the Department of Children and Families were also notified and that they're currently in your custody, correct?
Actually, ma'am, as a correction, the children was not present. This happened in the street. I don't know why they were notified, but I have been in contact with them, and I'm going down to family court because my kids is not safe. I'm not safe, my kids is not safe.
Okay. So I'm just gonna order that if DCF does get involved, which it sounds like they did, somehow law enforcement got them involved, that he just abide by any plan that you and DCF come up with.
Yeah.
Okay, okay. So Mr. Rosario, I am gonna go ahead and find that there's probable cause. I will appoint the public defender's office to represent you. I am gonna set your bond at $1,000 on count 1. Count 2 will have a $100 bond. I am gonna issue this no contact order. That piece of paper that you're signing is indicating that you've been aware of the no contact order. It does remain in place until the trial judge in Division 17 says otherwise. Obviously, I'm just going to indicate that you're going to maintain a separate residence, which you already do, and that you not possess any weapons or firearms, and that you abide by any plan that DCF puts into place. Okay? Good luck to you, sir. Thank you. Good luck, ma'am. Thank you. Hi, good morning. Are you Patrick Sidholm?
Yes, ma'am.
Okay, Mr. Sidholm, you are here on a couple of cases. Let me first talk to, this is Ms. Kozam. And Ms. Kozam, can I get you to raise your right hand for me? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth? Okay, so Ms. Kozam, it's my understanding that this is your ex-husband. The two of you have been separated for quite some time, and that you do currently have this injunction in place to try to keep him away. I would assume that you are wanting that injunction to remain, and that you want a no contact order to remain in place as well as a condition of this case.
Correct.
Okay. Was there anything else that you wanted me to know?
There was originally a 7-year injunction between us.
Can you do me a favor? You're the only one in that box, so if you don't mind, yeah, I can hear you a little bit better without the mask.
There was originally a 7-year injunction between him and I. He violated the injunction, and now we have a permanent injunction. I have full custody of our daughter. He still contacts me, messages me, and contacts me knowingly he should not be contacting me. He contacted me yesterday, resulting of why we're here today.
Okay, well, thank you.
He's also on probation.
Yeah, we're gonna get to that too. So in case number 2023 MM240AO, or 2400AO, Mr. Stidholm, you are entitled to a bond on that case. I am gonna set the bond in the amount of $1,000. The conditions are that you have no contact with your ex, and that you're to maintain a separate residence from her. You're not to have any contact with her in any way, shape, or form. You're not to possess any weapons or firearms. I am going to appoint the Public Defender's Office to represent you. Sir, because this does violate your probation in case number 2022 CF 6104AO, I am going to note that there's probable cause for the violation of probation. The bond on that will be set at none. I will go ahead and appoint the Public Defender's Office to represent you. There is a third case, which is 2023 CF 4543AO. I'll appoint the Public Defender's Office to represent you on that charge. The bond will stay at $2,000 on count 1 and $100 on count 2. And I believe that covers everything. So, ma'am, I did have to give him a bond in the misdemeanor, but he currently is being held without any bond due to the violation of probation. So just stay in contact with the state attorney's office, and they can update you about the case as well.
Sorry, I'm confused. So because there is some bond and no bond, is he going to be released or no?
No, he will not be released because he's being held no bond on the violation of probation. Okay? Okay. Thank you. Good luck, sir. Thank you. Okay, next I have Rogelio Vidal Diaz.
Yes, ma'am.
Okay, good morning, sir.
Good morning.
You're here on case number 2023 CF 4554AO. Sir, I did review the charges in this case. I am finding that there's probable cause. I will go ahead also and appoint the Public Defender's Office to represent you. Sir, I guess the most important thing for us to discuss this morning is that you understand that without Ms. Otero here, and quite honestly, even if she were here, I'm going to issue a no contact order. That means you're not to see her, call her, email her, text message her, send her any cards, letters, or gifts, or have any contact with her through any other person. That no contact order remains in effect until the judge in Division 15 changes that. Let me see one thing here. Am I correct that count 1 is a PBL?
The way it's currently charged under 4A, it is, but that is for a victim under the age of 18, or under 12, I believe. The victim allegedly was 39, I believe.
It's his wife.
39. So it should have been charged as 4B. So it is not going to be a PBL, it would just be an F1 due to the age of the victim. However, when setting bond due to him being entitled to it, state would just ask that you take into account the allegations within the affidavit and that there are multiple other things that could have and probably should have been charged and were not. So state would just ask that you take that into account because state is concerned regarding the safety of the victim, given what's alleged within the affidavit and given his criminal history. There appears to be other violent offenses, other batteries, other sexual assaults, stalking.
And I only see that he was convicted of batteries. Your Honor, I don't see any type of convictions for stalking or sexual assault, so I just ask that you consider that when setting the bond. He only has one failure to appear from 2005.
Mr. Vidal, you technically are entitled to a bond under state statute and under the law, the way it's written. I certainly understand that this is your wife and that
Don't talk.
certain people have certain ideas about things, but in my mind, and I don't want you to respond in any way, shape, or form. If there's something that you think I need to know, you can let your attorney do that. But I do think the seriousness of these allegations are very serious and very violent. I am going to set your bond in the amount of $10,000 on count 1. I'll set count 2 at $500. I'm going to order that you have the no contact, that you not return to where you live with her, that you maintain a separate residence. If you need to retrieve belongings, you may do so one time with law enforcement officers, and that you're not to possess any weapons or firearms. Okay? Good luck to you, sir. Thank you.
That's a different issue, so you want to call the attorney, because that's a family issue. Mm-hmm.
That's it.
Mm-hmm.
Thank you. Thank you. Have a good day.
Good day, sir. Okay, good morning. Are you Tamia Clark? Yes. Ms. Clark? Okay, Ms. Clark, you're here on case number 2023 MM2398AO. I am finding that there's probable cause on this charge. Were you wanting to have the public defender's office appointed to represent you, or are you gonna hire your own attorney?
I'll just use the public defender.
The public defender? Okay, so I'll go ahead and get them appointed to represent you. Does she qualify now or no? It looked like she wasn't interviewed, so she didn't qualify.
Your Honor, I believe her history is back and everything that's in the system. The only thing that they had cited was unable to verify her community ties because of the instability of the living situation. But that was the only thing that I can see. There wasn't an alternative address provided. She's, I guess.
Okay. Okay. So Ms. Clark, as long as you can find someplace else to live other than being with Mr. LaFrance, I'll do it this way. I'll put that you qualify for pretrial release or a $500 bond. The conditions are that you have no contact with the victim, that you maintain a separate residence from him, that you not possess any weapons or firearms. If there are any belongings that you need from that home, I will allow you to return one time with law enforcement officers.
Your Honor, with the way that's worded, is it going to be PTR or bond, or will it just be?
PTR or bond.
But it's not PTR if qualifies, but, because she does, I mean, if you.
No,
want
I'm
to, we
saying
can
it
put her on
sounds
P-
like as long as she can give you that other address, that should be fine,
If
right?
you want to, we can give her PTR and I'll set her up for the next day, if you just want to do PTR. If that's
Okay, I'll just do PTR then. That way you don't have to worry about trying to pay money to get out.
Okay.
Okay, yeah, thank you. Okay, good morning. This is Alanis Gonzalez Moreno.
Yes, ma'am.
And we're here on case number 2023 MM2396AO. I believe in the box should be Kevin Ramirez.
Kevin Nieves.
Nieves. Mr. Nieves, can I get you to raise your right hand? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. So, Mr. Nieves, you are the alleged victim in this case. Were you wanting me to keep up the no contact order, or were you wanting me to allow her to come home and have a no
I
hostage?
want you to allow her to come home.
Okay. So, Ms. Gonzalez, you do qualify for pretrial release. I'll go ahead and appoint the public defender's office to represent you. The only conditions of your release will be that you have no hostile contact with Mr. Nieves. DCF was notified, so you just need to also abide by any plan that they put in place and no weapons or firearms, okay? Do you have any questions?
No.
Okay, good luck to both of you. Thank you. Hi, good morning. Are you Vanessa Gonzalez? Ms. Gonzalez, you are here on case number 2023 MM80AE. Sir, you are the alleged victim in this case. You are Ms. Gonzalez's husband. I'll be honest with you, I don't have your name, so can you tell me your name?
Richard Rivera.
Okay. And sir, can you raise your right hand? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. So, sir, you've heard all these cases before. Did you want your wife to come home, or
Definitely come home.
so a no hostile contact order will be sufficient to keep the two of you safe?
No, we're good.
Okay. Well, I have to do it. I have to do
fine.
something, so I'll just do the no hostile.
Fine.
Okay. So, Ms. Gonzalez, you do qualify for pretrial release. I'll appoint the public defenders. The only condition of your release is that you have no hostile contact with your husband, and no weapons or firearms, okay? Do you have any questions? Okay, you're both free to go. Thank you so much. Good luck. Christy Rodriguez? Okay, Ms. Rodriguez, you are here on case number 2023 MM2391AO. I have reviewed the charging affidavit in this case. I am finding that there's probable cause. I will go ahead and appoint the public defender's office to represent you. You do qualify for pretrial release, so I will go ahead and release you on a straight pretrial release. The condition is, though, that you have no contact with the alleged victim in this case, Mr. Barbosa. Now, understanding that he is your fiance, that you may not want that to last forever. It is not permanent, but it is something that can only be changed by the trial judge, Judge McGinnis. So if you want that to change, or you think he wants that to change, make sure you get with your attorney and get in front of him. Now, the way I was reading the charging affidavit, it sounded like the two of you don't live together, but do you live together? Okay, you have someplace else you can stay, so I will go ahead and impose that you maintain a separate residence. If you do need to retrieve any belongings at your home that you share with him, you may do so one time with law enforcement officers, and I'm also going to impose that you not possess any weapons or firearms. Do you have any questions? No. Okay, good luck, ma'am. Thank you. Hi, good morning, sir. Are you Noberto Santiago?
Yes, sir.
Sir, you're here on case number 2023 MM2399AO. And I believe in the box is, let's see, hold on. Peggy Rosa Benitez?
Yes, that's
Okay. Ms. Benitez, can you raise your right hand? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
correct.
Okay, thank you. So, ma'am, it's my understanding that this is your husband. You guys have been married for 15 years. You've heard what I've said previously. Are you wanting me to continue with the no contact order, or were you more comfortable with the no hostile contact?
I don't want no contact for the moment.
Say that one more time.
I don't want no contact for the moment.
Okay, and so you understand that that no contact order, it's not necessarily permanent, but it goes with the conditions of his release, that he will not be able to have any contact with you at this time. But if that is something that you do, if you work together and want to change it in the future, you do have to do that in front of the trial judge. Now, let me ask you, I don't think. Okay, DCF was notified. That was the thing. You do have children together, correct?
Yes, we do have a daughter,
Okay.
one girl.
And DCF, have they reached out to you yet this morning?
Yes, I do have a message from them.
Okay, so just stay in contact with them. So, Mr. Santiago, you do qualify for pretrial release, so I'll go ahead and release you so that you're not on a monetary bond. You will be supervised by pretrial services. I'll go ahead and appoint the public defender's office to represent you. I am going to include that you have no contact with your wife at this time. You signing that piece of paper is just you acknowledging that you've been told that. Like I told your wife, it's not necessarily permanent, but just until things calm down a little bit, let's just not have any contact. If you want to change that, Judge McGinnis can do that, but he does have to be the one that does that. You're obviously going to need to maintain a separate residence from her. If you need to retrieve any belongings, you may do so one time with law enforcement officers. I'm also going to put that you not possess any weapons or firearms and that you abide by any plan that DCF puts into place. Do you have any questions? Okay, good luck, sir. Thank you. Good luck, ma'am. Thank you. Okay, good morning. Are you able,
Yes.
how do you say your last name?
Tension, Your Honor.
Cencion de la Rosa?
Yeah.
Okay. And Abel, you're here on 2023 MM2390AO. And I believe that this is Ms. Rodriguez, correct? And ma'am, can I get you to raise your right hand? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth? Okay. Ms. Rodriguez, you've heard me talking before. Are you wanting a no contact order or did you want to have a no hostile contact order?
No hostile contact order.
And you feel like that would be safe for you?
Yeah.
Okay, okay. So, sir, I am going to go ahead and find probable cause. I'll appoint the public defender's office to represent you. You do qualify for pretrial release, so that way you don't have to pay any money to get out of jail. You'll just be supervised by pretrial services. The only conditions are that you have no hostile contact with her and that you not possess any weapons or firearms. Do you have any questions?
So I can't buy a gun until when?
Until the case is closed.
Okay.
Okay?
So I can leave?
Yep, you'll be supervised by pretrial services and she'll be able to pick you up, but it just may take a few hours before you get out.
Thank you, Your Honor.
Okay, good luck. Thank you. Okay, good morning, sir. Are you Raymond Lee Kelly? Okay, Mr. Kelly, you are here on a warrant out of Brevard County of 2022. Oh, CT, I don't need to tell you all that, but it's a Brevard County warrant. It does appear that this is for a failure to appear for a plea. They did set your bond at $1,000. Let me see. My guess is, were you maybe supposed to be in Brevard County for that plea when you were here?
I just was in here a couple weeks ago. I got out without my charges here withdrawn. They took me to Brevard, charges withdrawn. I just thought that my court date, I had the court date mixed up. That's why I
We'll
was
talk
leaving
about.
over.
Okay, that's fine. So what I'm gonna do is you're being held because you're out on bond on Orange County charges. I'm not gonna take any action on that. So this will no longer hold you. You have the $1,000 bond that you can get out from Brevard. So you can either pay the bond to get out, or you can wait for Brevard to come back and pick you up, okay? Does that make sense? So the only reason you saw me this morning is because you were being held because they're showing that you're out on bond for charges in Orange County for possession of methamphetamines, resisting, false ID and stuff. So,
I'm not out on bond in Orange County.
okay, well,
33-day motion on those charges. I'm not on.
right, so you're out on an
It's the
ROR.
same thing. That means you're out on
It's not the
release.
same thing, though.
But you're out on release is what she's saying.
You're out on conditions of release.
So all I'm in here for right now is to be held for Brevard County, right?
Mm-hmm.
And how long do Brevard have? That's what I'm trying to figure out.
So Brevard has 24 hours to come and pick you up. Hopefully they will do that. If they don't, you also have the ability to pay $1,000 to get out of jail, but hopefully they'll come and pick you up. But what you're out on for the ROR is no longer gonna hold you. That's the only reason you saw me this
So
morning.
if the Brevard doesn't come get me within 24 hours, what happens? I get to get out.
And you'll come back before a judge and then we'll decide what's going on. But they're gonna come and pick you up.
Yes, they're gonna come get you.
Okay, Brianna Torrey, I apologize, Miss Torrey, you're here on a fugitive warrant out of, I don't know where it's out of. Kentucky? Yes, Kentucky. The bond has been set at none. Huh? None, 0.
Oh, okay.
Sorry, just none, there's no bond. So what that means is the fugitive unit is gonna get with you, and then talk to you about what you wanna do. If you wanna contest the warrant, you can do that. And then there's a process you go through, but I just have to make you aware of all of that process. Okay? Okay, thank you.
No public defenders involved with those, are there?
Yeah, I wasn't gonna.
Relatively.
This is Roberto Javier Rivera.
Yes, ma'am.
Mr. Rivera, good morning, sir. You're here on a bunch of cases. Let's see. So I have a violation of probation. Gosh, I'm totally going blind. This is in case number 2015 CF 3137AO. I am gonna find that Judge Strobridge signed that warrant. She has set your bond at none. We'll go ahead and appoint the Public Defender's Office to represent you. There's also a violation of probation in 2015 CF 5067AO, also signed by Judge Strobridge with a no bond. There's also case number 2015 CF 13485AO. That's also a violation of probation, bond set at none. There's also 2015 CF 5958AO, also a warrant signed by Judge Strobridge with no bond. And then I have a 2023 CT 239AA. It's a driving while license suspended or revoked charge. I'll stay your bond at $500 and appoint the Public Defender's Office. There's also case number 2023 MM168AA. It's a resisting officer without violence charge. I'll stay the bond and appoint the public defender's office to represent you. Okay, good luck to you, sir. Thank you. Is that everything? Okay, thank you, guys. I will see you tomorrow. Judge Carter will be here at 1. She'll probably come earlier, so I'll ask her if she wants to start earlier, she'll let you know.
And Your Honor, just really quick for the record, on Valentina, the reset, Valentine Kai, the one you found PC for,
Yeah.
they did provide, I was provided from the attorney who handled the case, I was actually provided case law that, that shows that based on the kicking of the door to enter the home, that was not enough for a burglary of a conveyance, burglary of a dwelling, that there must be a distinct and actual crime therein. The officer states that they could not charge him with the thefts that occurred because not only the victim stated he did not have enough time to steal the items and hide them, none of the items that were missing from the home was found on Mr. Valentine. So that is why there was no PC found in that case from yesterday, Your Honor. I believe we thought that the theft was attached to Mr. Valentine, but they couldn't charge him with the petty theft because they stated he did not have enough time to take the items, hide them by the time the officers were there.
How about, can we reset it to tomorrow?
Can we, please?
Yeah, is that okay? And I'll read over it again. I'll be honest with you, I didn't read it that clearly because I was thinking we were gonna get something else. So I'll read it again tomorrow.
Thank you, Your Honor.
Yeah. Can I have Judge, okay, my husband's gonna kill me as it is. So
That's it.
I'll
Thank
have,
you, Your Honor.
I'll have Judge Carter do the ROR motions.
That's fine.
And then you guys will be good to go. Thank you so
Thank
much,
you.
and I'll see you in the morning.
Hello at the jail, can you hear me and see me? Can you hear me and see me? Okay, perfect. I'm gonna go ahead and play the video.
You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you have, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers. Thank you.
Usted se encuentra aquí para una audiencia o vista preliminaria, después de haber sido arrestado. Las leyes y estatutos criminales del estado de la Florida requieren que se celebre una vista preliminaria ante un oficial judicial dentro de un plazo de 24 horas después de su arresto. El propósito de esta vista preliminaria es para que el juez pronuncie los cargos contra usted, para que se le comunique a usted sus derechos procesales y para determinar las condiciones de su libertad o fianza. Ya usted debería haber recibido una copia de estas alegaciones o acusaciones por escrito. Ahora, el juez revisará la documentación en su caso para determinar si existe motivo fundado o causa probable para su arresto y detención. Si el juez determina que existe causa probable o motivo fundado, entonces decidirá si usted califica para que se le otorgue una fianza, tanto como cuáles serían las condiciones monetarias o no monetarias de dicha fianza. Si el juez no posee suficiente información para determinar si existe causa probable o motivo fundado para justificar el arresto, se le concederá a la Fiscalía tiempo adicional para modificar la documentación. También se les avisa que posee los siguientes derechos que se les otorgan por la Constitución. A usted no se le puede obligar a decir nada durante esta vista. Cualquier cosa que diga podrá ser utilizada en su contra como evidencia. Usted tiene el derecho de comunicarse con un abogado, pariente o amigo, y si es necesario, que se les proporcione los medios razonables y disponibles para hacerlo. Usted tiene el derecho a un abogado. Si todavía no ha encontrado o contratado un abogado y no tiene los recursos para hacerlos, entonces el juez le nombrará un defensor público. Para el propósito de la audiencia preliminaria de hoy, se le permitirá hablar brevemente con un abogado de la Oficina del Defensor Público, aun cuando no se le haya nombrado para representarle en todo el caso. Para poder recibir la designación de un abogado, primero debe calificar económicamente según lo determine el juez. Esto será basado en la información financiera que usted proporcione aquí. Por lo tanto, si no lo ha hecho todavía, de la mejor manera posible, por favor, llene el formulario de insolvencia económica que se le ha proporcionado por el oficial de correcciones. Se le impondrá un recargo o costo por los servicios del defensor público. Si usted no habla inglés, por favor, hágale saber al oficial de correcciones. Cuando esté listo, el juez comenzará el proceso llamando a cada una persona y caso por su nombre. Por favor, esté pendiente para pasar adelante cuando escuche su nombre y cuando escuche su nombre, haga el favor de acercarse al micrófono tal como le indique el oficial de correcciones. Muchas gracias por su atención.
All right, good afternoon, everyone.
Good afternoon. This is Dale Rodriguez, certified Spanish interpreter, previously sworn.
Good afternoon. I'm calling case number 2023 CF1031, the state of Florida versus Luis Bernier Santos.
Denied above guidelines.
Okay. Please state your name and date of birth, sir.
Luis Bernier Santos, 821-76.
Luis Avenue Santos, 821-77.
Right. Mr. Santos, you're here for an initial appearance on 3 charges this afternoon.
Señor Santos se encuentra aquí para llevar a cabo una comparecencia inicial con respecto a 3 cargos.
Sí.
Yes.
Charges are false imprisonment, misdemeanor battery, and tampering with a witness.
Los cargos son privación de la libertad, agresión física y manipulación de un testigo.
Let me take appearances for the state.
Comparecencias por la parte de la Fiscalía.
Charles Fink for the state, Your Honor.
And I'm sorry, Madam
Charles
Clerk,
from the
what did you
parte de la
announce with
Fiscalía.
respect to appointment?
This person is denied above guidelines. They do not qualify for.
Y disculpe, ¿qué fue lo que indicó secretaria acerca de la designación? Se encuentra por encima de los límites, así que no reúne los requisitos para defensor público.
Although you have sought appointment of the Public Defender's Office to represent you, you do not qualify.
A pesar de que ha buscado que el defensor público le pueda asistir, usted no reúne los requisitos para la asistencia de ellos.
State have any request with respect to bond?
Fiscalía, ¿hay algo que desean pedir con respecto a la fianza?
Nothing in particular, Your Honor, just reasonable according to these charges with, state would suggest conditions of no contact and no return. I don't know if the alleged victim has anything to say here.
I'm going to find probable cause for each of the charged offenses.
No hay nada en particular, solamente se pide que la fianza sea razonable conforme a las acusaciones y la Fiscalía pide que se le prohíba el trato con la víctima y se le prohíba regresar al lugar. No sé si es que la víctima tenga más que decir. Determino que existen los indicios de criminalidad con respecto a cada una de las acusaciones.
Mr. Santos, your wife is present here in the courtroom.
Señor Santos, ¿su esposa se encuentra aquí presente en la sala?
No.
Is
No.
that, is that not right?
Yeah, it's me. You already don't see me.
Okay. Do you require an interpreter?
¿Requiere un intérprete?
All right.
We'll
No.
see, so he can understand.
Okay. You have a right to be present. You can simply observe these proceedings, or you can tell me any information that you'd like me to know in setting the conditions of the defendant's release on bond. Is there anything you'd like me to know?
Yeah, I would.
Bueno, tiene el derecho a estar presente y puede observar el procedimiento e indicarme los términos en caso de que se le fuese dar libertad al acusado. ¿Hay alguna cosa que me quisiera indicar?
Do you solemnly swear or affirm that the testimony you shall give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
See,
What would you like me to know?
Él es un hombre muy bueno, él es un hombre ejemplar. Yo no me siento acosada ni con miedo de mi vida, ni me siento amenazada. Nosotros llevamos casados 28 años, hemos estado juntos 31 si contamos los años de novio.
Let me have the interpreter the opportunity to catch up. Mr. Interpreter?
¿Jura decir la verdad, toda la verdad y nada más que la verdad? Sí. ¿Qué quisiera que sepa? Well, he's a very good man. As long as I've been with him, I haven't felt harassed or I haven't been afraid of my life or threatened. We've been married for 28 years. You could say that we've been together for 31 years as a couple.
Yo no tengo ningún miedo de él, ni que regrese a la casa. Yo no quiero que él vaya a la cárcel. Esto fue un incidente de él solo una vez. Él nunca me había puesto una mano encima. Y no lo hizo, él simplemente trató de sacarme de su lado y cerrar la puerta para que yo no me fuera. Y yo no quiero que él vaya a la cárcel por algo, porque como le digo, si usted mira su récord, él nunca ha tenido ningún problema con la ley y es un gran padre y esposo.
And I'm not afraid of him, and I don't want him to go to jail at all. I don't want him. This has never ever happened. It's only been once that's happened, and even then, he's never really put his hands on me. He's never really done anything. The only thing that he did was, just try to get me off of him and try to close the door so I wouldn't leave. Well, I wouldn't like him to go to jail. But all I'm saying is, if you take a look at his record, you could see that he's never had any problems with the law. He's a good father and a good husband.
Y yo quiero que regrese a casa con sus hijos.
And I want him to go back home with his kids.
All right, thank you, ma'am. You can take a seat if you'd like.
Gracias, señora. Por favor, puede tomar asiento si desea.
Does the state wish to be heard any further with respect to bond or conditions of release?
No, Your Honor.
Fiscalía, ¿hay algo más que desean pronunciar con respecto a la fianza o las condiciones para que sea liberado?
Bond is set with respect to count 1 in the amount of $1,000, count 2, $150, count 3, $250. Conditions of the defendant's release, that the defendant shall have no hostile contact with the alleged victim in the case. Anything else, State?
Entonces, se va a fijar la fianza para el primer cargo a $1,000, con respecto al segundo cargo sería 150 y con respecto al tercero 250. Una de las medidas para que el acusado sea puesto en libertad es que tiene prohibido cualquier tipo de trato hostil con la presunta víctima del caso. ¿Alguna otra cosa, Fiscalía?
I don't know. We didn't have any testimony about whether there are any weapons or firearms in the home. Would request no weapons, no firearms.
As an additional condition of the defendant's release, the defendant shall not possess weapons, ammunition, or firearms.
No sé si ha sido parte del testimonio que se ha indicado que haya habido armas o armas de fuego. Entonces, se le pide que por favor se trate eso como una medida adicional para que el acusado sea puesto en libertad. Tiene prohibido la tenencia de armas de fuego, munición o cualquier otro tipo de armas.
Yes.
Su señoría, sí. La libertad provisional. Él reúne los requisitos para una fianza con libertad provisional.
I'm comfortable with strictly monetary bond.
Me siento conforme con una fianza estrictamente monetaria. Gracias, señoría.
Mr. Interpreter, if you will remain on the line for the next case as well. 3 cases, State of Florida versus Juan Zambrano Polo, 2023 CT 1616, 2023 CT 1617, 2023 CT 1619.
PD appointed.
I apologize, ma'am. Please get the case numbers for the previous defendant, the one that we just finished.
Previous defendant's case number is 23 CF 1031.
Thank you.
Sir, would you please state your name and date of birth?
Señor, por favor, indique su nombre y fecha de nacimiento. Juan Carlos Zambrano, 181071.
Appearance for the state, please.
Comparecencia de la Fiscalía, por favor.
State, if you'll make your appearance on the record.
Charles Fink for the state.
Fiscalía, a constar su comparecencia en
And
actas,
for
pronunciaciones de
the
parte de la
defense, please.
Fiscalía. Y la defensa, por favor.
Thank you, Ms. Anderson.
Rachel Anderson, de parte de la Oficina del Defensor Público. Gracias,
Sir,
señora Anderson.
You have all the rights explained to you in the recording that was played prior to the calling of this case.
Señor, todos sus derechos han sido explicados a usted en la grabación que fue reproducida antes de que se hiciera esta llamada del caso.
The public defender has been appointed to represent you in the case.
Se le ha asignado al defensor público para que lo asista en su caso.
You've been charged in 3 cases with 3 traffic infractions, operating a motor vehicle without a valid license,
Entonces ha sido acusado de 3 diferentes casos, de 3 infracciones de ley de tránsito. Uno es por conducir un vehículo sin una licencia válida,
operating a motor vehicle without the appropriate vehicle registration,
conducir un vehículo sin el permiso de circulación debido
and operating a motor vehicle with the registered license plate not attached.
y conducir un vehículo con una matrícula que no corresponde.
I've reviewed the arrest affidavit and find probable cause for each of the charged offenses.
He estudiado la affidavit de arresto y he determinado que existen los indicios de criminalidad para cada uno de los ilícitos.
Does the defense wish to be heard with respect to bond?
¿La defensa desea ser oída con respecto a la fianza? Su señoría, figura que el señor Zambrano no reúne los requisitos para libertad provisional, así que se pide una cantidad baja de fianza que sea razonable.
State wish to be heard?
No, Your Honor.
Fiscalía, ¿es algo que desea pronunciar? No, señoría.
Bond is set with respect to each of the offenses in the amount of $100.
Se fija caución con respecto a cada una de las acusaciones por $100.
And as an additional condition of release, the defendant will not operate a motor vehicle without a valid license.
Y como una medida adicional para que sea puesto en libertad, el acusado tiene prohibido conducir un vehículo sin una licencia válida.
Anything else on the case? State.
No, Your Honor.
Anything else
Fiscalía,
for the
¿algo más?
defense?
Fiscalía, ¿algo más
That
con respecto al
concludes
caso?
your
No,
initial
señoría.
appearance in this matter, sir. Thank you.
¿Defensa algo más? No, señoría. Esto concluye la comparecencia inicial. Muchas gracias, señor.
Next court date for 23 CT 1616, 1617, and 1619 is still in jail. April 20th, if out May 5th, in courtroom 5B at 8:30 a.m.
La siguiente fecha para la que le tenga que comparecer con respecto al caso 23 CT 1616, 1617 y 1619 sería, si aún permanece en la cárcel, el 20 de abril, si no, el 5 de mayo a las 8:30.
Is an interpreter required with respect to Jose Clemente? All right. All right, that appears to be all the cases we have for you. Mr. Interpreter, you can disconnect. Thank you.
Thank you very much, Your Honor. Have a great day.
You too. The next case is the State of Florida versus Theodore Sherrod. Sherrrod.
Orange County case number 2022-00411620.
Good afternoon, sir. If you'd please state your name and date of birth. All right, thank you, Mr. Sherrod. You've got all the rights that were described to you in the recording that preceded my calling your case. You've sought appointment of the public defender. Does he qualify?
Because it's an out-of-town judge, they don't, give him
All right, I'll provisionally appoint the public defender for the purposes of this hearing. Mr. Sherrod, You've been arrested on a warrant out of Orange County for charges of possession of a controlled substance for which bond is set in the amount of $1,500. I've appointed the public defender for the purposes of this proceeding. Probable cause has already been determined, I believe, based on the issuance of the warrant. Does the state wish to be heard?
State just requests that the bond be stayed.
Ms. Anderson, did the defense wish to be heard? All right, the court will stay the bond on the outstanding warrant.
Next
Thank you,
court
sir.
date on demand.
The next case is 2023 MM797, the state of Florida versus Whitney Garcia Ortiz.
PD appointed.
Your Honor, she refused. Can we get a 24-hour recess?
Case will be reset for initial appearance tomorrow. The next case is 2023 MM798, in Miami-Dade County case as well.
Denied above guidelines. And Miami case number is M71096.
That's state of Florida versus Jose Navarro. All right, sir, if you'd please state your name and date of birth. And your date of birth, please. All right, thank you, sir. You've got all the rights that were described to you in the recording that preceded my calling your case. I'll take appearance for the state, please, on Mr. Navarro's case.
Charles Fink for the state.
And Okay, I'll appoint the public defender's office for the purposes of this hearing. Mr. Navarro has requested that. Ms. Anderson, I'm sorry, did you say you had a probable cause argument with respect to the new case?
Yes, Your Honor, with respect to resisting arrest without violence.
All right, you can go ahead.
Mr. Navarro was charged with resisting arrest without violence under Florida Statute 843.02. The statute requires that at the time of the resisting, obstructing, opposing, the defendant knew that the alleged victim was law enforcement. There's no indication in the charging affidavit that he would know that, Your Honor. The facts don't mention that the officer was wearing a uniform, wearing a badge. He just really says there was a command to get away from the young lady or her. So Mr. Navarro's out there anyway. So I would argue that based on this affidavit, the facts are sufficient to rise to cross based on the fact knowledge.
What says the state?
I didn't catch every word of that, but is the gist of it that he didn't know it was a law enforcement officer? I recognize that the affidavit does not say he was wearing his uniform. However, it does say that he deployed his agency-issued taser, which I'd never seen a law enforcement officer deploy without being in uniform and having it on them. That's all I could offer. If the court doesn't want to find probable cause on it, then we could request a one-day reset to get additional facts.
Sure.
It is oftentimes that plainclothes officers or people who are not law enforcement carry tasers, guns, other weapons, Your Honor. In addition, defendants would object to a 24-hour reset. While the court does allow resets for good faith reasons to get supplemental information, the officer's inability or negligence to write a complete report is not good faith reasons that the party. I would request that Mr. Navarro be ROR to the case of resisting without violence.
All right. I'm confined to the four corners of the charging affidavit, and nothing in the charging affidavit indicates that the alleged law enforcement officer identified himself as a law enforcement officer, and I don't think it's necessarily a reasonable inference that the fact that he discharged his taser means that would permit the reasonable inference that he was in fact in uniform. Court will deny the request for a 24-hour reset and will release the defendant on his own recognizance with respect to the charge in 2023 MM 798. As to the Miami-Dade case, did you wish to be heard, State?
I would request the bond be stayed at 0 and let Miami deal with that.
Counsel?
Your Honor, given the fact that there was sufficient probable cause for the charge which led to the violation, I request that you set a bond.
This is not clear to me. Okay, so this is an on-view VOP, not violation of the conditions of his pretrial release, is that right?
That's right, that's right.
I'm going to reconsider my prior ruling. The court will grant the state a 24-hour reset in order to provide supplemental allegations to the charging affidavit. I'll take no action on the Miami case and we'll address it within 24 hours. Well, what would you like me to do, State?
I request a 24-hour reset for additional facts.
That's as to the resisting charge.
As to the resisting charge, yeah.
Okay.
The Miami, I mean, if this case, if it's the resisting case that's violating the probation, I mean, I was attempting to look up whatever that probation entails. It could have entailed a no contact. It could have entailed no alcohol. I don't know what it entailed, so I don't know if there's other facts in there that may play into it other than just the resisting.
Your Honor, I have a question just for clarification.
Yes.
The violation probation is the Miami case, right?
Yes.
In that case, and I believe it's the court's discretion, but the defense requests that Mr. Navarro remain ROR without the 24-hour reset, and then Your Honor would allow him to stay in bond and allow him to be transported to Miami for that case.
My concern is that the material that I've been provided would mean that Mr. Navarro qualifies as a violent felony offender of special concern and would therefore not be entitled to a bond on the VOP. So, not ROR'd, he'll remain in custody for a 24-hour reset when we'll address the Miami case as well. State, I mean,
The jail is gonna want.
he's not going to be released because there's an alleged violation, right?
Correct, but
Right, well, so we'll stay the bond at $500, but it's neither here nor there, given the pending VOP.
yes, Judge, thank you.
The next case is 2023 CF 1032, the state of Florida versus Alani Nelson.
TV appointed.
Sir, would you please state your name and date of birth for the record?
Alani Nelson, 17, 1987.
All right, thank you, Mr. Nelson. You've been previously advised of all the rights in the record that you have in the recording that preceded my calling your case. You're here for an initial appearance on 2 charges, the first of which is misdemeanor battery, and the second of which is hindering communication to a law enforcement officer. You've sought appointment of the public defender, and you do qualify, so I'll appoint the public defender to represent you for the purposes of this hearing. Appearance for the state, please,
Charles Fink for the state.
and for the defense.
Rachel Anderson on behalf of the public.
Public defender wish to be heard with respect to probable cause.
No, Your Honor.
I've reviewed the arrest affidavit in your case, sir, and I'll find that there is probable cause with respect to each of the charged offenses. This case is on a no-bond status, given the allegations of domestic violence. State wish to be heard with respect to bond.
Yes, state would ask for the appropriate bond to be set, and in the absence of any victim testimony, no contact, no return, no weapons, no firearms.
All right, ma'am, could you please identify yourself for the record?
Chantal Flanagan.
All right, Ms. Flanagan, if you please raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you shall give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Ms. Flanagan, you've got the right to be present as the alleged victim in this case. You can do that simply by observing these proceedings, or you can tell me what you'd like me to know in terms of fashioning appropriate conditions of the defendant's release on bond. What would you like me to know?
That he's a good dude. He just got very anger issues. He's a good father to my kids and also his.
You don't share children in common. That's my understanding. Okay. But you do reside together.
Yes.
State have any questions of Ms. Flanagan?
I'm sorry, could you repeat for me what she said so far? I just had trouble.
She said he's a good dude who had some anger issues.
Okay.
Is that right?
Yes.
Are you afraid of the defendant?
When he's mad, yes.
Is that yes?
Yes.
You're afraid? Okay. You both reside together at this address currently?
Yes.
Okay. Do you want the court to impose a no contact order for now?
Yes.
Okay. Are you aware of him possessing any weapons or firearms specifically?
Yes, he do have.
He has firearms? Okay. Nothing further, Your Honor.
Ms. Anderson, do the defendant's minor children reside at the shared address?
Yes, Your Honor, the children reside at Mr. Nelson's residence, actually his residence. He lives in the
I'm sorry, say that again?
according to the defendant, yes, the children reside there. The address is his address. The alleged victim is merely a visitor.
I think she might disagree with that characterization. Ms. Flanagan, do you reside at that address?
Yes.
Counsel, do you know if DCF has been involved?
I do not. I don't have that information.
Right. So, Ms., go ahead.
I'm sorry, I was just gonna make the court aware that Mr. Nelson does qualify for pretrial release with a bond. We would ask at that time that the court would consider allowing him to participate in pretrial release with a low bond.
Well, can you address specifically conditions of release, non-monetary conditions of release?
Yes, Your Honor, the defense would request that the court is to maintain a set of residence that Mr. Nelson would be allowed to be at the residence, his residence, based on the information I was told
Well, I don't have any evidence before me regarding either party's status with respect to that residence, so I'll simply set bond as to the misdemeanor battery charge in the amount of $250, and as to the hindering communication to law enforcement in the amount of $1,000. The conditions of release are that the defendant have no contact with the alleged victim in the case, no return to the shared residence. He'll be permitted a one-time return with law enforcement for the purposes of obtaining his personal effects, and he'll be directed to maintain a separate residence from the defendant, separate and apart from the residence at 2740 Swoop Circle. Anything else, State?
State would request no weapons, no firearms.
Thank you for reminding me. In addition, the defendant shall not possess weapons, firearms, or ammunition. And would you request a surrender?
Yes, if he's in possession of any.
All right, and the defendant will be required to surrender any weapons in his possession within 24 hours of the date of his release to law enforcement. Anything else on the case from the defense?
Yes, Your Honor, just for clarification, this is solely on Trayvon Charles.
Correct. All right, thank you, Ms. Flanagan. That concludes the initial appearance in this case.
Next court date on demand.
The next case is the State of Florida versus Cody Olson, 2023 MM801 and 2023 CT1611.
Be appointed.
Good afternoon, sir. If you'd please raise your right hand to be sworn. Actually, we don't need to have you sworn. Just state your name and date of birth for me.
Cody, 8889.
All right, thank you, Mr. Olson. That's O-L-S-O-N, is that right?
Yes, sir.
All right, you are here for an initial appearance on two cases, 2023 MM801, in which case you are charged with misdemeanor stalking, and 2023 CT1611. And in that case, you're charged with driving under the influence of drugs or alcohol. You have all the rights that were explained to you at the beginning of these initial appearances in the recording that was played, and you've requested appointment of the public defender to represent you for the purposes of this proceeding, so I'll appoint the public defender to represent you because you do qualify. Defense wish to be heard as to probable cause? The court will, based on the charging affidavit that I've reviewed, find there is probable cause for each of the charged offenses, misdemeanor stalking and driving under the influence of drugs or alcohol. State wish to be heard as to bond and conditions of release.
Conditions, state would request no contact, no return to the victim's address, and no alcohol.
Ms. Anderson, did you wish to be heard? Court will set bond as to the misdemeanor stalking charge in the amount of $1,000 and as to the driving under the influence charge in the amount of $150. As additional conditions of release, the defendant is directed in 2023 MM801 to have no contact with the alleged victim in that case. And no return to the scene of the alleged offense. Ms. Anderson, does the defendant reside at that scene? All right. Additionally, while on release in 2023 CT1611, the defendant shall not possess or consume alcohol or controlled substances without a prescription. Anything else on the case, State?
No, Your Honor.
Anything else, defense? All right, thank you, sir. That concludes your hearing in this matter.
Next court date for 23 MM801 on demand and 23 CT1611 is still in jail. April 20th, they filed April 28th from 4 a.m. 9 a.m.
The next case is Javar Reed, 2023 CF1037.
Be appointed.
Mr. Mr. Reed, could you please state your name and date of birth? All right, thank you, Mr. Reed. You're here for an initial appearance this morning on a single charge of petty theft with 2 or more prior theft convictions. You have sought appointment of the public defender to represent you, and since you qualify, I'll appoint the public defender's office to represent you. Any argument as to probable cause defense? All right, I've reviewed the affidavit in support of your arrest, Mr. Reed, and we'll find there's probable cause for that offense. Public defender's been appointed. Ms. Anderson, do you wish to be heard as to bond?
Yes, Your Honor, Mr. Reed does qualify for direct property, so I consider allowing that.
State wish to be heard?
No, Your Honor.
Right. The defendant is released to pretrial release without monetary bond. Additionally, he'll have no return to the scene of the alleged offense. Anything else on the case, Ms. Anderson?
No, Your Honor.
All right, thank you, Mr. Reed. That concludes your hearing.
Next court date on demand.
The next case is 2023 MM803, the state of Florida versus Helen Salazar.
PD appointed.
Good afternoon, ma'am. If you'd please state your name and date of birth for me. All right, thank you. You're here for an initial appearance this afternoon on a single charge of misdemeanor battery. You have all the rights that were outlined to you in the recording that you listened to prior to the beginning of this hearing. You've requested appointment of the public defender, and you do qualify, so I'll appoint the public defender to represent you. Does the defense wish to be heard as to probable cause?
No, Your Honor.
Court will find probable cause for the charged offense. State wish to be heard as to bond and conditions of release?
With a reasonable bond, state requests no contact, no return. State also requests revocation of bond in 23 CF 784.
Court will set bond as to 2023 MM803 in the amount of $250. Additional conditions of the defendant's release so that she have no contact with the alleged victim in the case and no return. I guess let's see, no return. No return to the scene of the offense. Did the defense wish to be heard with respect to revocation of release in 2023 CF 784? All right, in 2023 CF 784, Ms. Salazar, you were charged with possession of a controlled substance, possession of drug paraphernalia, and failure of a convicted felon to register as required by Florida law. The court has found that there's probable cause to believe that you committed the offense of misdemeanor battery, and by doing so, you violated the conditions of your release. Accordingly, the court will revoke the defendant's release in 2023 CF 784. Bond will be addressed by the judge assigned to that division. Thank you.
Next court date on demand.
The next case is 2023 MM804 and 2023 MM805, the state of Florida versus Michael Vasquez.
PD appointed.
Please have the request, Your Honor, and I'll argue the marriage term.
All right, thank you. Mr. Vasquez, would you please state your name and date of birth?
Yes, Michael Vasquez, 12/12/81.
All right, thank you, Mr. Vasquez. You have all the rights that were described to you in the recording that you listened to prior to my calling your case. You've sought appointment of the public defender to represent you in this case, and you do qualify, so I've appointed the public defender in each of the cases for today's proceeding. Ms. Anderson, you can proceed.
Yes, Your Honor, Mr. Vasquez was charged with battery, Florida statute 784.03, that could require an intentional touch or strike by the defendant and the alleged victim against his or her will. The affidavit indicates that the alleged
Isn't the allegation that the defendant grabbed De Leon's arm in and of itself sufficient to support a charge of battery?
It is, Your Honor. The defense was just arguing that that was more of a self-defense sort of thing, that the alleged victim was the primary aggressor because she hit Ms. Vasquez in the eye with that cell phone. Subsequent to that is when he grabbed her arm, the arm holding the cell phone.
All right, State.
Yes, Your Honor. The allegation that Vasquez grabbed De Leon's arm is sufficient for PC for battery in this case.
All right, Mr. Vasquez, in 2023 MM804, you're charged with misdemeanor battery. The court finds there is probable cause in the charging affidavit to support that. In 2023 MM804, you're charged with criminal mischief. The court finds that there's probable cause for that charge as well. We need to set bond, but I guess I'm more concerned about the conditions of release. My information from pretrial release indicates that the victim wants contact but does not want the defendant to return to their shared home at 282 Pine Valley Road, Apartment B. State?
State not having any contact with the victim, state would still request no contact, no return, maintain separate residences. Yeah, that's all.
Ms. Anderson, did you wish to be heard any further as to conditions of release?
Yes, Your Honor, the information I was provided by pretrial release, similar to Your Honor, indicates that the pretrial release had contact with the alleged victim. She does want contact with Mrs. Vasquez. The defense asked for non-hostile contact or the reporter contact.
So I don't think I've got sufficient evidence to make an informed decision regarding contact with the alleged victim, and she's not here to provide me any testimony. So in an abundance of caution, the court will set bond in the amount of $250 in 2023 MM804, the charge of battery, and $150 in 2023 MM805 for the charge of criminal mischief. In 2023 MM804, the conditions of release are that the defendant is to have no contact with the alleged victim, no return to the scene of the offense, and he'll be directed to maintain separate residence from the alleged victim, but permitted to return one time with law enforcement for the purpose of obtaining his personal effects. Obviously, the division judge, upon motion and the presentation of evidence, can make a determination as to whether or not that should be modified to hostile contact, but I'm not in a position to do that now. State wish to be heard any further?
No, Your Honor.
Defense? All right, that concludes the initial appearance in this matter, sir. Thank you.
Next court date on demand.
Next case, State of Florida versus Tajarvis Wall, 2023 MM806.
City appointed. He's present.
Sir, would you please state your name and date of birth? All right, Mr. Wall, you have all the rights that were described in the recording that you listened to prior to my calling your case. You've sought appointment of the public defender to represent you for the purposes of this initial appearance, and you qualify, so I'll appoint Ms. Anderson in the public defender's office to represent you. You're here on a single charge of misdemeanor battery. Does the defense wish to be heard as to probable cause?
No, Your Honor.
All right, the court will find that there's probable cause for the charged offense, misdemeanor battery. State wish to be heard as to bond and conditions of release.
State would request no contact, no return, maintain separate residences, Your Honor.
All right, present here in the courtroom is the defendant's sister. Ma'am, could you identify yourself, please?
My name is LaToya Wall.
All right. Please raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you shall give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, Ms. Wall, you were sitting in the gallery earlier, and I kind of described for a couple of folks your entitlement to be heard. You can simply appear and observe, or you can tell me what you think I need to know in fashioning appropriate conditions of release for your brother, Mr. Wall. What would you like me to know?
I asked that the charges on him be dismissed. When they came to the house on last night, I told them several times I didn't want to press charges or have him arrested. We came down here on vacation and pretty much we was having a family gathering. Things got a little out of hand. And the police came out, they immediately arrested him. Both of us was arguing with each other.
Where do you live?
We live in Charlotte. We supposed to been on the highway at 5 o'clock this morning.
Do you and Mr. Wall live together?
That's my baby brother. We don't live together though.
State, do you have any questions of Ms. Wall?
Are you afraid of your brother?
No, I am not.
What's that?
No, I'm not.
You're not. If something like this or any other violent incidences were to occur, will you call 911 if necessary?
I don't believe nothing like this else would occur. Pretty much it just, things had got out of hand. And we never had an altercation like this. We never fought each other. Me and my brother stick together. So it just got out of line.
Does Mr. Wall possess any weapons to your knowledge?
No, he don't.
Okay. Nothing further.
Ms. Anderson, did you have any questions of Ms. Wall?
Just briefly, ma'am, do you wish to have contact with Ms. Wall? Yes.
All right, based on Ms. Wall's testimony, the court will release the defendant on his own recognizance with respect to the sole charge of misdemeanor battery, and will impose a condition of release that the defendant is to have no hostile contact with you, Ms. Wall. All right?
Yes, sir.
Anything else, State?
No, Your Honor.
Anything else, defense?
No, Your Honor.
All right, that concludes your initial appearance, Mr. Wall.
So what would take place from here?
He'll be,
So he get out, we don't have to go sign a bond or nothing?
no.
Okay, so pick him up now from the. Okay, so he don't wait on pretrial or nothing? Okay.
All right, thank you, ma'am.
Next court date on demand.
I have no further cases on the docket. Anything, Mr., for the state? Oh.
Have any what? I have a Serrano on it. Okay, thank you. That's all.
Ms. Anderson, anything further?
No, Your Honor, thank you.
All right, thank you both very much.
Oh, do you? Yes. It's quiet. I like it so much. Have them at my desk upstairs.
I love it. And it's so nice and slow.
Thank you both. Thank you.
And they clean the bottom. And I like it.
Doesn't matter. Doesn't matter.
And they look at me and, yeah. Yep, that's why I put it here.
See you tomorrow.
I go out your doors.
Yes, of course. Y'all can be seated. It's okay, just let me know when you're ready. Well, let me just see what they want to do. Can you get WebEx going? That's all right.
I'm fine, thank you.
All right, great. This is 2019 CA 960, Santos versus Down South Vapors Incorporated et al. I'll take appearances here in the courtroom, and then we've got a couple folks appearing remotely. For the plaintiff,
Fanny Nader for Raul Santos.
Rosalind Figueroa for Raul Santos.
and for the defendant here in the courtroom,
For the defendant, Scott Damon here, Your Honor, on behalf of SDI Co. Limited, Samsung SDI.
all right, thank you. And I think those appearing remotely are just kind of observing. Would you like to make your appearances? All right. Mr. Bear, can you hear me? All right, rather than take time working out the technology, the court will just note for the record that David Baer is present and David Caballero is present as well. And who do they represent, Mr. Damon?
Let me check, Your Honor. I have to double check as
Ms.
to.
Nader, do you know?
Mr. Caballero, I believe, represents Lightfire, and Mr. Bear represents Down South, no, BMI, I'm sorry, BMI.
All right. Not sure exactly what's going on, but in any event, we're here on the defendant's second amended omnibus motion to dismiss for lack of personal jurisdiction. I've been provided material in chambers and I've reviewed it. How are we going to be proceeding today, Mr. Damon? Is there a stipulation to determine this based on the affidavits? Because it seems to me there are conflicting affidavits.
I believe that we are just going to be proceeding, Your Honor, on the affidavits. And the reason, to Your Honor's question, that we had noticed this as an evidentiary hearing is I don't think there are conflicts in the affidavits. And I'm not saying that to be argumentative, but as Your Honor is aware, under the Venetian Salami case, in the event that there are conflicts between facts that the court needs to resolve, that's the reason, of course, to have an evidentiary hearing. There are no live witnesses, and we had stipulated about that previously. So
I guess I said it wrong. The affidavits conflict with the allegation of the operative complaint. But go ahead.
That's absolutely true, Your Honor. But to that point, because that's an important issue, I believe that the court will determine that ultimately there are disagreements, of course, between the plaintiff and defendant as to characterize what's the effect of the evidence in the form of affidavits before the court and how that applies to the law on personal jurisdiction, obviously. But I don't think we're going to have conflicts and on facts in terms of one says black and one says white, that type of thing. There may be arguments about is that a relevant fact, et cetera. But I don't think we're going to have conflicting facts so that the court, I believe, unless Ms. Nader has something else, will just be proceeding with the submissions already provided to Your Honor, both in filing and to chambers in the form of affidavit, and then obviously the argument and briefing in our motion, and then the response from the plaintiff. I believe that's all that it will be encompassed for today.
Okay. I had proposed exhibits provided. Are we marking those and receiving them in evidence? I mean, it seems like you teed this up as an evidentiary hearing, but everybody acknowledges that it's evidentiary in the sense that there's an agreed set of evidence that you want me to rule on. So how do you want to perfect your record? Because I would imagine that it's going to be appealed either way.
I'm comfortable proceeding as Your Honor just described. That these are sets of evidence that the parties agree are to be submitted and considered by the court, as opposed to walking through the official steps to mark each individually. I believe we can make a proper record by what we filed with the court, and obviously the courtesy copies provided to Your Honor, so that it's not necessary to walk through evidence. I think that's more streamlined and still allow the court to consider everything the court needs to consider in this issue.
I would agree.
Hopefully that'll be streamlined, Your Honor.
Okay. All right, so Ms. Nader, I have in front of me plaintiff's notice of filing exhibits in support of plaintiff's response in opposition to Samsung's motion. There are 9 items listed in that notice. Are those the same 9 items that the defendant is relying on?
Your Honor, the plaintiff is relying on those. We're not relying on them. We don't have a dispute with them. I think one of them, there was a request to take judicial notice, and I'm not clear exactly on what the nature of the request is, but candidly, we don't think that the item, which is referenced to a website, is of any significance to the jurisdictional determination here. So rather than get bogged down in minutia for that, we're not relying on them, but we acknowledge that the plaintiff wishes the court to consider, so that's part of the record that the court may consider is our position.
Is there a similar listing of the evidence on which your client relies?
Yes, Your Honor. Though actually, the list, I think, is a list of one, which is the affidavit of Mr. Shin provided from Samsung SDI. It is in our, it was attached, it was filed and attached with our motion to dismiss, and it also was provided, and I know you've got a lot of material, Your Honor, so I know that's overwhelming, but it was at tab 2, actually, hold on, it was at tab 4 of the material we provided to Your Honor. It's defendant's notice of filing affidavit in support of second amended omnibus motion, which is the affidavit of Mr. Shin from Samsung in Korea.
All right. So then, on the stipulation of the parties, is it fair to say that the affidavit of Mr. Shin is received in evidence as Defense Exhibit 1?
That's fine with us, Your Honor, yes.
Right. And is it fair to say then that all the documents delineated in the plaintiff's notice of filing, specifically no, I've lost it. In the April 5th filing, exhibits 1 through 8, is it fair to say that those are stipulated to and can be received in evidence as plaintiff's exhibits 1 through 8?
Yes, Your Honor.
Mr. Damon?
Yes, Your Honor. In fact, I just noticed that Exhibit 3 is our notice of filing, I presume, with the affidavit of Mr. Shin attached.
Okay.
So that essentially what plaintiff has encompasses everything, if that helps to streamline. I had forgotten that that was the way that was.
Slightly redundant, but that's fine. I just wanted to make sure we had everything squared away in terms of the evidence. All right, so without further ado, Mr. Damon, you can proceed.
All right, very well. Your Honor, if that's okay, may I speak from here just because I have, papers laid before me? I've not
Absolutely.
been in your courtroom, so I wanted to conduct myself the way the court would like.
Nope, that's fine.
If that's okay, may I?
You can be seated as well.
Okay, I usually prefer to stand, but to go over some of the details of this, it may be easier for reading and covering this more succinctly with the court. Let me start, Your Honor. This is a very unusual circumstance. I've never had anything like it, Your Honor, with respect to the fact that, as the court now knows from reviewing the materials we provided, this issue about whether or not there is properly personal jurisdiction over my client, Samsung SDI, has already been decided, obviously not in the Santos case, but in the Bennett Fields case that we provided to Your Honor less than a year ago. And the cases are extremely parallel and have virtually identical facts. And we are going to go over today, and I'm sure plaintiff obviously will note today, the differences, which we already noted to the court in our written submissions. But really, the only difference related to jurisdictional circumstances and facts is the fact that this case, the Santos case, relates to a purchase of a product in May of 2016 and an accident in September of 2016, whereas the Fields case, which is the first District Court of Appeals opinion that analyzed the exact issues with the exact same facts as this case, which was decided again less than a year ago. So we're in the very unusual circumstance where an appellate court has already reviewed a trial court, in that case, it was a Leon County trial court decision that in that case, as Your Honor probably saw, the trial court had denied the motion to dismiss for lack of personal jurisdiction, finding jurisdiction over Samsung SDI, and then was reversed by the first DCA, and it walked through exactly the same analysis that we're going to go through here today, Your Honor. And I don't think there's really any question that the analysis that's walked through, the plaintiff is going to have some issue about some of the final conclusions, but the legal principles, the legal precedent that applies really isn't in dispute today. So the real question is going to be applying that to the facts of our case, and we think that ultimately, we understand that this court makes its own decisions and obviously, has its own, proper power and focus on applying the facts of this case. And we agree with plaintiff who pointed out in their memo that each case has to be decided on its own, and we fully agree with that. But here it's so unique because the facts of the Fields versus Samsung SDI case, those jurisdictional facts are identical except for the time frame. And the affidavit that we provided from Mr. Shin includes all the same facts, literally every single one that is cited in the decision by the first DCA in explaining why there is no personal jurisdiction over Samsung in that case. And for that reason, there is not properly jurisdiction over Samsung in this case as well. And I'm going to walk through that. The first thing I'd like to do, Your Honor, is walk through the background facts. I know we really appreciate the time the court has taken to review this, but I just want to make sure, just so it's fresh in all of our heads to do the analysis, I'm going to walk through first the kind of the factual background and allegations, then I'm going to get to the jurisdictional specific part, and obviously the standard to meet the requirement to establish personal jurisdiction. And I'm going to do that by walking through the Fields case. So let me start with the background, and I'll try to go through this briefly. But as Your Honor knows, this is a claim for personal injury by the plaintiff, Mr. Santos, arising out of the use of an e-cigarette. And I'm taking all this from plaintiff's complaint, so these are not my characterizations, just straight what the allegations are from the plaintiff himself. And plaintiff alleges that the co-defendant, Down South Vapors, is in the business of supplying, selling, importing, and or distributing electronic cigarette vaporizers and component parts and accessories. That comes from the paragraph 5 of the plaintiff's complaint. Lightfire Group was the wholesaler, again from plaintiff's complaint at paragraph 9. Lightfire was the wholesaler and distributor of SDI Co. manufactured size 18650 purple wrapped lithium batteries in the state of Florida. So that's plaintiff's allegation that Lightfire was the distributor for the product that ultimately ended up in Mr. Santos's hands. Plaintiff alleges that defendant SDI Co., my client, was and is the manufacturer of the size 18650 lithium ion battery that's the subject of the lawsuit. And that, plaintiff alleges in their complaint, paragraph 11, that many of these resale companies, well, actually, the plaintiff describes that there are resale companies. In this case, there's a company called Shenzhen that's alleged in plaintiff's complaint. It's in China that apparently takes Samsung SDI batteries, this particular 18650 lithium-ion battery, and rewraps it. They obtain it from a source that there is no evidence. We don't know where it comes from. Plaintiff doesn't know where it comes from, so there's no evidence about how is it that Shenzhen gets the apparent Samsung lithium-ion batteries. And they rewrap it, they put their own name on it, and it's the purple-wrapped E-Fest, which is referred to by plaintiff throughout their complaint. So this battery is then distributed, and we're not sure exactly how or where, but ultimately it ends up, according to plaintiff's own allegations, in the hands of Lightfire Group, which they allege is the distributor of the wholesaler and distributor. That was from paragraph 9 of the complaint. And then it further gets into the hands of Down South Vapor. And then from Down South Vapor, it was sold to the plaintiff Santos. So as you're going to see, Your Honor, as we walk through the affidavit from Mr. Shin, none of the process I've just described involves any effort or will or intention on the part of my client, Samsung SDI. All of it was unauthorized. All of it was outside of any channel of distribution or sale that Samsung has or takes any part of whatsoever.
Did you characterize Shingen as a wholesaler?
We don't even know. I mean, in the sense that somehow, some way, they sold it to someone who sold it ultimately to Lightfire, who sold it to Down South, who sold it to the plaintiff, apparently. We have no idea other than it, because they're the one that wrapped it. I don't know whether someone else distributed it from there or was a wholesaler or distributor. Somehow, according to plaintiff's own allegations, it was rewrapped with their name and sold somehow, some way. So exactly their function or how they participate in some long chain to get to the plaintiff, we're not sure, and we don't have evidence that either the plaintiff or defendant does, Your Honor. So I've walked through kind of the chain of how it is that this, that the specific 18650 individual battery by plaintiff's own description, got into the hands of Mr. Santos. So on May 28, 2016, the plaintiff purchased what they alleged to be a Samsung SDI battery from Down South Vapors. Let me emphasize an important point. We're happy to consider, for purposes of today's hearing, plaintiff has alleged that it is Samsung's battery, before it got changed and wrapped by another company without knowledge and without participation of SDI. Plaintiff alleges that the battery that actually injured Mr. Santos was manufactured by SDI. We don't have any knowledge of that one way or the other. We haven't seen the battery. We haven't been provided it. That's just an allegation. But for purposes of today's hearing, we have no choice but to assume that's true for purposes of the allegations, even though we haven't seen it. We asked informally to be able to see it or see the reports or photographing of the battery, and we haven't seen it. But that's the allegation, so it's what we will have to work with for today's hearing.
So I understand that, given that, the answer to my question might not be particularly relevant, but I'm curious, does the defense agree that the way that Mr. Yan determined that it was a Samsung battery is a reliable way of determining the provenance of a battery?
I don't have any idea is the short answer. I think it's Ms. Yan. I assumed it was Mr. as well, but I think I saw a reference to a feminine pronoun. We don't know the answer. We haven't seen it. And the other concern is the battery that blew up. It's not clear to me whether that is the battery that was actually evaluated by the engineer, because there were two batteries in the pants pocket of Mr. Santos when the apparent explosion occurred. And one of them was found, according to the complaint. The other one, because it doesn't say, and it can only infer, the other wasn't. So I don't know whether the one that was found was the battery that exploded. I wouldn't think it would be testable at that point in time, but we just don't know because those aren't facts before us. And the good news is, I don't think they ultimately change anything about the jurisdictional analysis for today, but they would be relevant for trying to understand the case more fully, for merits-focused issues.
But assuming it's the one that caused injury and assuming that it's a Samsung battery, still there is no personal jurisdiction. That's your argument?
Absolutely, Your Honor.
Okay.
Again, ultimately because plaintiff, can't and hasn't established the requisite showing that they've met the requirements of the long-arm statute, and they can't establish the due process requirements for minimum contacts of purposeful availment and relatedness. So regardless, even if we all knew as a certainty this was a battery originally manufactured by Samsung, it wouldn't have any effect on the analysis and the argument for today. All right, so continuing, the plaintiff had two batteries in his pocket on September 15, 2016. I'm reading from the complaint, paragraph 26. It says, the entire e-cigarette configuration was in one pocket, and the backup subject batteries were in his lower right pants pocket with no other items contained therein. And then paragraph 27 of plaintiff's complaint says that on September 15, 2016, at about 11 a.m., the plaintiff was injured when the plaintiff returned to his truck, and while sitting in the truck, suddenly and without warning felt heat in the area of the subject's spare batteries in his pocket, followed by an incendiary explosion. And plaintiff's allegations in the case, as Your Honor knows, are that SDI, separate from the other three defendants, but SDI is allegedly responsible for negligence in its manufacture or design of the battery and its alleged failure to warn. And there's a strict liability count. And there's also the last thing that we'll get to, Your Honor, from my side of the argument, which is there's a fraudulent concealment claim, which is count 8, which relates to the idea that we fraudulently concealed information that would have warned the plaintiff of the alleged defect in the battery. So those are the three counts. And again, just for background about what the claim is. So next, I want to talk about what SDI's business, or really more accurately, lack of business in Florida is. And ultimately, the most important question is, what is the connection between SDI's business in Florida and this actual suit or claim or injury, which is the important question for determining jurisdiction along with satisfying the requirements of the long-arm statute. So this is from our memorandum at page 10. I'm trying to walk through it similar to the way that we argued it in writing, Your Honor. SDI's lithium-ion battery cells are not designed or marketed to be used individually or outside a battery pack. This is an extremely important fact that relates to understanding the entirety of the factual pattern for the case. And this is the fact that was emphasized and part of the important decision of the first DCA when it also reviewed this exact same personal jurisdiction question for SDI as in the Bennett Fields case. So the significant, that comes from the Shin affidavit, paragraph 21. So to make sure this is clear to the court, when Samsung sells these 18650 batteries, they are not sold to be used by any individual consumers for anything. They're not sold as individual batteries, the way the court might picture a AA or a AAA battery where you go and buy, one or two or a pack of 6 of them, and you can take 1 or 2 of them and put it in a device. That is not how the 18650 lithium-ion batteries are used. It's not how it's sold. And there are multiple statements in the affidavit of Mr. Shin that explain quite clearly the only way that these 18650 lithium-ion batteries are sold is sold in packs, in groups, to either be packed directly by the person that purchases. When I say the person, it's really a sophisticated business entity, a company that buys them and puts them in a pack, either designed by my client SDI or designed by our purchaser to be run in a pack so that they're all together operated by a battery management system. This is explained in the affidavit. But the importance of the battery management system is these individual cells, if you took one 18650 battery cell out and just walked around with it or used it, they're not intended to be used anywhere for anyone in any context as an individual battery. So in reality, as plaintiff describes that the product that Mr. Santos is using isn't actually an individual consumer product. It is a component part of a pack that's meant to be used only with a battery management system. And we have explained that in Mr. Shin's affidavit, and I'm going to walk through that in further detail. But this is extremely important because plaintiff argues repeatedly that, well, this is a product that we failed to warn consumers about. It's not a product. This individual cell, whether it's 1 or 2 or 8 of them or 20 walking around, they're never intended to be used by any member of the public, not just in Florida, not in America, not anywhere on the planet. So in reality, it's something that's a misuse of a component that is built into a larger product, which is a battery pack that can only be safely operated with a battery management system. So continuing on from Mr. Shin's affidavit, as we explained in our motion to dismiss, SDI has never authorized any distributor, wholesaler, retailer, or reseller to advertise or sell 18650 lithium-ion battery cells individually, and that means anywhere, ever. SDI Co. has never authorized any distributor, wholesaler, retailer, or reseller to advertise or sell lithium-ion batteries to be used without the control of a battery management system, which is what I was just explaining. SDI Co. has never authorized any third party to use SDI Co. products for any vaping devices. So they're not allowed to be used for anything, and there's even particular concerns or dangers for using them in vaping devices. That was from the Shin Affidavit, paragraph 45. So now going on a little bit more to SDI's relationship to Florida. The Shin Affidavit explains at paragraph 16 that SDI has never sold any product of any type to any retail stores in Florida. So not only are we not selling, batteries that are never supposed to be used individually and never supposed to be used by just a regular consumer, we don't sell anything retail into Florida at all of any kind. SDI Co. has never conducted any business with defendant Down South Vapors. We haven't conducted any business with Lightfire Group. We haven't conducted any business with BMI. That's all from the Shin Affidavit, paragraph 17. We've never conducted any business with Mr. Santos. That's paragraph 18 of the Shin Affidavit. When plaintiff alleges in paragraph 8 of their third amended complaint that Lightfire Group, and I'm quoting, quote, is a wholesale agent for all major brands of e-cigs, vapor products, and accessories, including the subject Samsung SDI Co. Limited manufactured size 18650 E-Fest purple wrapped lithium ion batteries, is incorrect or misleading. And the reason, again, as we explained in the kind of the description of how it is these batteries come, SDI has no relationship with Lightfire, none with Down South, none with BMI, the manufacturer of the actual e-cigarette device. When I say no relationship, just to be clear about that, no contract, there's no distribution agreement, no retail agreement, no sales agreement, no kind of agreement at all. So the idea that, and the allegation of the plaintiff is just not correct, that somehow they are an authorized distributor or seller or marketer is completely not correct, and that's our affidavit, and there's no contrary evidence as to that. There's just an allegation that is ultimately not correct at all. The same thing for Down South, no relationship whatsoever, and as already mentioned, none with Mr. Santos, also none with the e-cigarette device maker. All right, so the Shin Affidavit explains at paragraph 36, SDI does not ship, sell, or distribute individual 18650 lithium-ion battery cells to Florida. They don't advertise or market individual 18650 lithium-ion battery cells in Florida or to Florida consumers. We've never shipped, SDI has never shipped individual 18650 lithium-ion battery cells to Florida to be used individually and outside a battery pack. That's the Shin Affidavit, paragraph 38. Again, that's just an important, baseline fact for understanding that the use that Mr. Santos had for the product, apparently encouraged by these other entities, was never a part of any chain of distribution or authorization or involvement of SDI whatsoever. That's abundantly clear from the Shin Affidavit. And then SDI has never authorized any third party to advertise, distribute, or sell individual 18650 lithium-ion battery cells for use by individual consumers. That's the Shin Affidavit at paragraph 41. SDI does not permit the use of 18650 lithium-ion battery cells in vaping devices. That's just one further use. Doesn't matter what kind of device, but it wouldn't be authorized, hasn't been authorized.